day's proceedings, seeking adjournment. Matter has been adjourned earlier on 4 occasions. Stop.
My Lordship, item 3.
Sorry, sir. Yes. Today, sorry, adjourn. To grant further opportunity to the petitioner, list for fresh admission in the week commencing. On 6 weeks, sir.
Oh, bless.
Your Lordship, item 7, Your Lordship. I'm for the petition.
You are dealing with around 350 matters. Upon your rate on 29 it's a reopening week or first week. Try to distribute.
Item 3,
Your Lordship,
sir.
item 7, Your Lordship.
Three mentioned question. Please watch your colleagues in the present in the court.
Yes, sir.
Three question, sir.
After vacation, sir. After vacation.
Upon one answer.
Kaushik Maharana.
Mr. Kaushik Maharana on behalf of Amitabh Tripathi for the petitioner. The matter is listed for fresh admission and is mentioned at the beginning of the day's proceeding, seeking adjournment on behalf of the learned counsel for the petitioner. Stop. The matter was earlier adjourned on 3 occasions.
2, 3.
On 7/4/2026, the matter was extensively heard. The facts and the legal issues were noted. Stop. To grant further opportunity to the petitioner, list in the week commencing. 6/7/2026.
Your Lordship, item 7, Your Lordship. I'm praying for an adjournment.
5.
Item 5 may be permitted to withdraw because 2 documents have to be added with liberty to file better.
So Gopal Prasad Jenna for the petitioner. The matter was heard at length on 21/4/2026. The petitioner had adjournment. The learned counsel was to address on the legal issues noted in the said order. Stop. Today the matter being in the list. Today the matter is listed for fresh admission and learned counsel for the petitioner mentions and files memo of date. Memo of date, which states thus. On 21/26, the following order was passed. In view of the memo, the petition stands disposed of. Yes.
With liberty.
Liberty देई होनी sir. Dismiss करूनी जब कहो dismiss कर देबी so that you can go in SLP. Liberty देई होनी sir. थोड़े hearing हला परे मु liberty देई परिबे.
मो डॉक्यूमेंट उडा फाइल करियो.
Document sir फाइल करा जाए. Hearing हला परे document फाइल करा जाए अपन जानछ. You are sir too senior and too experienced. Document अपन फाइल करे कोन असु. How can you say that documents not being filed liberty granted sir? Must understand. I should not look like a joker sitting here.
Mother has filed another one.
Sir, mother or father, sir, document file kara jaye, there is a procedure. Withdraw kara jaye. For filing of
outdated
documents. No. Disposed of apan jaha karibe.
Outdated and here what the bit of fruit.
Memo ta ko diyon. Because after dictating, I am not going to change the order. Ago memo diyon to tapare memo withdraw kare pe out memo diyon. Dita memo debe. Don't make it a fun, sir. I am not having fun here.
Item 7, Your Lordship. I'm seeking an
Ago
adjournment.
withdrawal memo debe. Tapare out memo debe. Withdrawing the withdrawal memo. Yes, 7.
Your Lordship, the case may be posted after vacation, Your Lordship. I'm seeking adjournment for that.
Apana kona hochi Miss
Suchasmita Das.
Ms. Suchasmita Das on behalf of Om Swarup for the petitioner. The matter is listed for fresh admission and is mentioned at the beginning of the day's proceeding, seeking adjournment on behalf of the petitioner. Earlier, the matter was adjourned on 17/26 and 7/4/26. Stop. To grant further opportunity to the petitioner, list in the week commencing. 29/6/2026.
Item 12.
Item 8, Your Lord.
You are Mr. Das. Upon Asit Kumar Jena.
No, madam. My name is P. Das.
Mr. P. Das for the petitioner. Item 8.
My lord, the conducting counsel, Mr. Ashit
Uh,
Kumar Jena, his mother has the expert. He has
Learned counsel for the adjournment is sought for on behalf of the learned counsel for the petitioner, though it is listed for fresh admission. You will claim on behalf of the learned counsel due to personal difficulty.
his mother has the expert.
সেটা লেখাই নিব স্যার ଆପଣ ଯୋଉ ଯିଏ ବି ଚାହାନ୍ତି ମଦର ଇନ୍ କୁ ଏକ୍ସପାୟାର କରାନ୍ତୁ ସେଟା ଟିକେ ଇଜିଅର ୱେ ମା ନା ବଡ ମା ନା ଖୁଡି କିଏ ଚାଲିବ
ତା ନିଜ ମା ମଧ୍ୟ।
that is how I'm not recording personal reasons se gala adjournment
Next week,
the matter shall be listed in the for fresh admission in the week commencing କେବେ ସାର୍ ଚାହୁଁଛୁ ଛୁଟି ପୂର୍ବରୁ ନା ପରେ
my lord, next week, your lordship.
କେବେ 18 ପାଇଁ commencing 18 ପାଇଁ
So, like,
My lord, item 12. Pray for
9 to 18
item 12.
ଆପଣଙ୍କ ନାଁ ସାର୍
BK Panda.
Mr. Brajokishwar Panda for the petitioner.
Paper after vacation.
The matter is listed for fresh admission. As it was presented on 24/4/2026. The adjournment is sought for at the beginning of the day's proceedings by the learned counsel for the petitioner. Stop to grant further opportunity to the petitioner listed in the week commencing 6/7/2026.
Page 3, 19 to 23.
Item 22, on behalf of Mr. Subhendu Parida, matter kindly taken up after vacation. Item 22.
Your name, sir?
My name Dinesh Kumar Mallik.
Mr. D.K. Mallik on behalf of Amit Bose Nahanti.
ନାଇଁ ନାଇଁ ଶୁଭେନ୍ଦୁ ପରିଡ଼ା ତାଙ୍କୁ ମଧ୍ୟ ମ୍ୟାଟରଟା ଟ୍ରାନ୍ସଫର ହେଇଯାଇଛି ବ୍ରିଫଟା।
On behalf of Subhendu Kumar Parida. For the petitioner. The matter is listed for orders. Matter was earlier adjourned on 5/12/2025. 10/3/2026. Thereafter, the petitioner has obtained change. And Sri S.K. Parida, Learned Counsel and Associates have entered appearance today. The matter is thought to be adjourned on ground of personal difficulty. Stop. Difficulty of the counsel for the petitioner to grant further opportunity. Matter shall be listed for orders in the week commencing. Date, sir. 29/6/2026.
Lordship, item number 23, my
20
lord.
Lordship.
ଆପଣଙ୍କ ନାଁ sir?
Ajit Kumar Rath.
କଣ ଅଜିତ କୁମାର ରଥ?
Lordship. Lordship, objection.
So you must write 1, 2, 3, 4.
There's two and two. Lordship.
Sir, order ସେଇଟା sufficiency of notice ନା କଣ ଆସିଛି? ଆପଣ adjourn କରିବେ କେମିତି ହବ sir?
Yes. Respondent number 3 ତାର ଆସିନାହିଁ।
ସେଇଟା ତ ଏମିତି mention out of turn କରିହବନି। ଏ order has to be passed.
Lordship.
ତ ଆପଣ ଯଦି ରହିବେନି କାହାକୁ କୁହନ୍ତୁ ଏମିତି କଣ କରାଯାଏ ଯେ ଆପଣ ଯେତେବେଳେ ଆସିବେ matter take up ହବ order pass ହବ ସେମିତି କରନ୍ତୁ।
Let it
That will be lead to
let it reach.
yes. ଆପଣ କାହା କହିଦିଅନ୍ତୁ order ଯାହା ଥିବ sufficiency or otherwise of notice.
Lordship.
21.
20, Your Lordship. 20. I'm seeking an adjournment, Your Lordship. I'm for the opposite party.
I'm for the petitioner.
20,
I'm for the petitioner.
21.
20, my lord.
ଆପଣ ନାଇଁ ସିଏ
So 20 by
21 में sir.
20, Your Lordship.
20, sorry, 20.
Yes, Your Lordship.
Acha.
20.
Yes, Mr. Mishra.
my lord, your lordship has directed on 10/4/2026
Mhm.
that in this situation both parties may make an endeavor.
Mhm.
I have called them thrice to Mr. Om Swarup and I talked with him.
Mhm.
Today in the morning he is requesting me to seek at least 1 week adjournment because thrice I have called him and requested that this is the order of the.
ବର୍ତ୍ତମାନ now it is not between husband and wife, it is between the lawyer and lawyer.
ମୁଁ ନାଇଁ I am
ଆପଣଙ୍କର ଠିକ ଅଛି
ମୁଁ ଚେଷ୍ଟା ବି କରୁଛି ଆଜ୍ଞା ସାର୍ ଦେବି
ଆପଣଙ୍କର ଗୋଟେ ଆଡଭୋକେଟ୍ସ ଆକ୍ଟ ରେ ଗୋଟେ କ୍ଲଜ ଆସିବାକୁ ପଡିବ ମିଡିଏସନ ତାହେଲେ ହବ ଯେ
ନାଇଁ ମୁଁ ବି ଚେଷ୍ଟା କରୁଛି ଆଜ୍ଞା ସାର୍ ଦେବି
ଭଲ କଥା sir.
your lordship may call it next week.
The matter is listed for orders. Item 20. The appearance ଦେଖିବେ Mr. A. Mishra for the petitioner. Miss Suchimita Das for the on behalf of Om Swarup for the opposite party. The matter is listed for orders and is mentioned jointly by the learned counsel for the petitioner, referring to order dated 10/4/2024. Particularly paragraph 4. This court is applying that the efforts are on to arrive at an amicable settlement and some further time may be granted. Stop. Accordingly, the matter shall be listed for orders in the week commencing.
Next week as well. Already say kotha hi jaychandi. Jaha instruction nebe.
Orders in 18/5 Next week, sir, actually say 110 cross kari galan.
18/5 ରେ ଆସିବ ଏଟା ସରିଯିବ ଆଜ୍ଞା
18/5 100 ହଉଛି ହେଇନି ଆଉ।
ନାଇଁ ଏଇଟା ଅର୍ଡର
ସାର୍ ଦିଟା ଦେଲେ ଓକିଲାତ ଗୋଟେ ମେମୋ ଦେବେ ୱିଥଡ୍ର କରିବା ପାଇଁ ଆଉ ଗୋଟେ ଦେବେ ୱିଥଡ୍ର କୁ ୱିଥଡ୍ର କରିବା ପାଇଁ। ଠିକ ଅଛି। ସେ ଅର୍ଡରରେ ଆଡ୍ କର। The memo states thus, the memo shall be taken on record. After few minutes of interaction, the learned counsel has a change of mind and he files another memo of date stating to withdraw the withdrawal memo. Withdrawal memo the court read. The said memo states thus. Accordingly, the matter shall be listed for the orders. For the orders, fresh admission for fresh admission छुट्टी परे ना पूर्व
ପରେ ଆସୁ
ଆପଣ ଖୋଜନ୍ତୁ ଡକ୍ୟୁମେଣ୍ଟ ଖୋଜିକି ଆଣନ୍ତୁ after the matter shall be listed for fresh admission in the week commencing 29 କୋଉଟା ଏକ ନମ୍ବର ମେମୋ 2 ନମ୍ବର ଆପଣ ଜାଣିପାରିବେ ମତେ ଦିଅ ସାର୍ ଲେଖିଲେ କି 1 ନମ୍ବର କୋଉଟା 2 ନମ୍ବର କୋଉଟା
1 ନମ୍ବର କୁ ପ୍ରଥମଟା ୱିଡ୍ରଆଲ ଅଛି ଦ୍ୱିତୀୟଟା ୱିଡ୍ରଆଲ
ଏଇଟା ଆଜ୍ଞା ଏଇଟା ଏକ ଲେଖିବେ ଆଉ ଦିନ ସାରା ଅଛି ଯଦି 3 ନମ୍ବର ଦେବେ ୱିଡ୍ର କରିବା ପାଇଁ ଦେବେ ଆଉ ଥରେ the saga should continue. Yes. Upon you are an officer of the court. धरନ୍ତୁ ମୁଁ ମାନେ କହିଦେବି ହଁ withdraw. ଆପଣଙ୍କ reason ଦେଖିଦେଲେ ମେ problem କଣ ହବ memory ଦେଖିଦେଲେ ଯେ to file documents. Say that cannot be a ground for withdrawal. Yes. 21, Mr. Mahapatra, 21, you are mentioning.
No, my lords, in order that the opposite party might seek for adjournment.
Acha.
There are no writs. There is no one.
ठीक अछि 21 to 23, then 24 to 28,
28, your lordship.
28.
For the petitioner, your lordship, 2 weeks time.
After
Madam,
notice matter है
Yes, your lordship, the after notice.
posting कर दो
13/7 week commencing 13/7
Interim order to continue, your lordship.
कौन adjournment अछि ना stay अछि
Stage. No
Stay
course of
is
action.
not touching unless I reach the matter I'm not touching I'm just posting it in the top आपण other side पे की नहीं
I'm for the opposite party.
आपण अछन
Item 28.
अच्छा अच्छा डेट 20 তে ডেট হবে তো আপনার
After vacation.
কেবে ডেট করলে
week commencing 13/7
13/7 week
Item 29, man.
yes please
I'm for the opinion number 2, man.
ठीक अदर साइड को मेंशन करंतु
Intimate sir, my son is
29 रे स्टेट 29 टा कहार आपनकर मिस्टर प्रभु
Sethi.
से कहउचंती ठीक है डेट कर दियो
OP2, man. My son is hospitalized, man.
नहीं अरे
week commencing
टेक केयर ऑफ वी कमेंसिंग
13/7
13/7
My, okay.
Your Lordship, I am appearing on behalf of Mr. Das in item number 18.
Item 105 or 2006 specific adjournment today.
फिर आवडे मेमो दियो आफ्टर नोटिस ना फ्रेश ना ऑर्डर
For orders, fine, sir. 23
ठीक प्रॉब्लम अछि केतरा डेट न हेलारु
sir.
केतरा डॉट डेट कोड न हेलारु सेटा ऐड हे जाउची
It is specific adjournment 4-5.
सेटा काहे के आसीनी केबे कोन थिला कि सेटा स्पेसिफिक अटेंडमेंट हवा कथा नु
Sir, orders thila. Orders se
वी
thila.
कमेंसिंग हवा कथा
23 Which commencing no?
स्पेसिफिक अटेंडमेंट होउनी स्पेसिफिक अटेंडमेंट हेले इट इज इम्पॉसिबल टू मैनेज
ठीक है sir.
आपनकर एई वीक रे को दिन ओटा आसीबो
Tomorrow, sir.
ना तुमरो कि डे आफ्टर सेटा स्पेसिफिक अटेंडमेंट हो नाही एवं वीक रे डिस्ट्रीब्यूट करी करा होछ
Sir, it was listed on 23/4/2000.
so when I am not adjourning specific adjournment how can I say direct for your case
Lordship has adjourned for 4/5/2004.
week commencing 4/5 must understand that is how we are able to manage it
Yes.
Your Lordship, I am appearing on behalf of Mr. Das in item number 18.
କେବେ ଗୋଟେ ଆପଣ ଏଇ ୱିକ୍ ରେ ତ ଆସିବ ଆସିବ ଆଜ୍ଞା
Item 32, I pray for adjournment. After vacation.
32 ମିଷ୍ଟର ସେଠି ୟେସ୍ 32 ଗୋଟେ ଡେଟ୍ କରନ୍ତୁ
We commencing 13/7.
ୟେସ୍
May I be pardoned, Your Lordship? Item 34, Your Lordship. Your Lordship, I pray for an adjournment.
34 ଡେଟ୍ କରିଦିଅନ୍ତୁ
Your Lordship, and identical matters are to be tagged up with this matter.
ସେଟା ତ ଫ୍ରେଶ ଆଡମିସନ କହିଥିଲେ ନା
Yes, Your
ଫ୍ରେଶ
Lordship.
ଆଡମିସନ ଆସିନି
No, sir.
ଦେବେ ମେମୋ ଦେବେ
Uh,
ୱି କମେନ୍ସିଂ 13/7 34 13/7 କହିଲେ ତ 13/7
interim to continue.
interim order since I am not touching it no change in interim order. It
Objection.
has to because it is the next date of hearing
Objection.
I may be pardoned, Your Lordship.
35 to 40
35 to 40,
call
I may be pardoned, Your Lordship.
item 1.
My lord, it may be referred to the mediation.
ନା ସେ ରାଜି ହେଲେ ସାର୍ ମେଡିଏସନ ପାଇଁ ସେ ଟାଇମ ନଉଥିଲେ ମହାନଦୀପ କୋଲଫିଲ୍ଡ ପାଇଁ କ୍ୟାପିୟର କରୁଛନ୍ତି ମାନେ ଚିତ୍ରକଳା ଇରିଗେସନ ଡିଭିଜନ
ଚିତ୍ରକଳା
yes mister any instruction
No instruction has come.
sir medicine को पठाले this is facing a problem ଆପଣଙ୍କର କିଛି ହଉନି ତାଙ୍କର ବି କିଛି ହଉନି ପଡିକି ରହୁଛି Mr. Sudhir Chandra Mahanti for the petitioner, Mr. Prem Kumar Mahanti. You are appearing or Mr. Lenka?
I am
Mr. Prem Kumar Mahanti, additional standing counsel for the petitioner. The learned counsel for the petitioner that the matter is listed under the heading for referral to, of course, also. Editor लिखिए. The learned counsel for the petitioner reiterates his prayer for referring of the matter to the mediation. He refers to the order ଆଗରୁ କିଛି ଅର୍ଡର ହେଇଥିଲା କି ମିଷ୍ଟର ମହାନ୍ତି ମନେ ପଡୁଛି ଓକେ ଆଇ ଫାଇଣ୍ଡ ଆଉଟ୍ refers to reiterates his prayer for referral to mediation. It is submitted by the Lord Additional Standing Counsel that he has not he is awaiting instruction reading referral of the matter to mediation as it involves expenditure from the state exchequer for payment of compensation amount. ଆପଣ କଣ ଏନହାନ୍ସମେଣ୍ଟଟା ରିଜେକ୍ଟ ହେଇଛି ନା ଏନହାନ୍ସମେଣ୍ଟ ଚାହୁଁଛନ୍ତି
ଏନ୍ହାନ୍ସ ଚାହୁଁଛି
ମାନେ ସେଠି ରେଫରାଲରେ ଯେତିକି ହେଲା କିଛି ହେଲାନି
ସେଠି ରେଫର ହେଇନି ଇଏ କନଫର୍ମ ହେଇକି
confirm करते the Lord AC seeks further time to obtain instruction. Accordingly, the matter shall be listed under the same heading in the week commencing
29.
29. Yes,
Item 4,
nice. Password per to activate.
item 6,
Password per to
item 9,
password.
item 10,
କି କଲ୍ ହେଲା ବେଳେ ଦେଖୁଥିବେ କି ଯଦି ସେଠି ରହିଯାଇଥିବେ
10 may I please, Your
ଆଉ
Lord?
ଗୋଟେ ମିଶା ପେବେ ଆଉ ଗୋଟେ କୋଉ କୋର୍ଟରେ ହେଲା ଦିଲ୍ଲୀରେ ନା କୋଉଠି କଣ ଆମର ତ ୱେଟିଂ ରୁମ୍ ସିଷ୍ଟମ ଅଛି ଆଉ କଣ
Item 10 may I please, Your Lordship?
Sir.
Lordship, I
10
make
10 10
10.
Mr. T Barik.
Yes, Your Lordship. I
T
make
Barik for the petitioner. Just one second. I'll
Yes.
get the file. Yes.
Lordship, I may kindly be permitted to withdraw this.
Memo depe.
Yes, Your Lordship.
ଆପଣଙ୍କ power ଅଛି ତ?
Yes, Your Lordship. I am giving.
Whenever you are withdrawing, you just have to ensure that you are having power. Mr. D. Parikh for the petitioner of 422026, the matter was hard at length. But para 1 टा repeat कर सकते हैं. 4 para 1 तापरे on 4/2/26 it was hard at length and the following order was passed. 2 to 5. तापरे thereafter the matter was hard on. Matter was adjourned on 10/3/26 by the petitioner. The following order was passed. 10/3 order. The matter was again adjourned on 9/4/26 and the following order was passed. Stop. Today, memo of date is filed by the Honorable Counsel for the petitioner, which states thus. So, accordingly, the matter is disposed of. If not, the memo shall be taken on record, scans copy be updated. The petition stands disposed of. Copy of this order shall be forwarded to the Honorable Judge. Family Court Balasur. Be kept in the records of CR.P. extension number EX. Extension to our EXP होगा of 300 of 202. Yes, next.
Item 11,
Pasu. Sorry. Okay. 11 next. Pass over.
item 13,
Pass over. Okay. 14, Madam Patnaik.
14,
May I please, Your Lordship?
Yes.
Well, in this case, my lord, the petitioner challenges the order of the Judge Family Court, my lord, passing a meager amount as entry maintenance, my lord.
Take note.
Where,
Take note.
well, where,
Sajay Lakshmi Patnaik for the petitioner. It's the petitioner wife in the
well, I have prepared.
Photos. Not a full lecture. Correct करो तो
So they are Lakshmi Patnaik.
ଆପଣ को ନା ଠିକ ଅଛି ଆପଣ ଇପ୍ସିତା କ ନାଟା ଇସ୍ପିତା କରିଦେଲେ
हाँ, बोल
ଏଟା ଭଲ ନାଟା
ମୁଁ बोली
ଏଇଟା ଗୋଟେ ଡିଫେକ୍ଟ ଆମର ବି ଷ୍ଟାମ୍ପ ରିପୋର୍ଟ ରେ କାରଣ ଆମର କଷ୍ଟ ଟାଇଟଲ ମ୍ୟାଚ ନ କଲେ ଟ୍ରାଏଲ କୋର୍ଟ ସାଙ୍ଗରେ କଷ୍ଟ ଟାଇଟଲ ଯେମିତି ହେଲେ ମ୍ୟାଚ କରିବ ନହେଲେ ଆଲାଉ କରିବେନି ଆଡ୍ରେସ ଆଣ୍ଡ ନେମ୍ ହାଜ ଟୁ ମ୍ୟାଚ ୱିଥ ଦ କଷ୍ଟ ଟାଇଟଲ ମୁଁ କହିଲି ବୋଧେ ଏମିତି ଗୋଟେ କଣ ଆଜିକାଲି ନୂଆ ଯୋଉ ନାଁ ଦିଆଯାଉଛି ଇସ୍ପିତା କରିଥିବେ
ପଏଣ୍ଟ ଆଉଟ୍ କରୁନାହାନ୍ତି
ସେ ବି କରୁନାହାନ୍ତି ଆପଣ ବୁଝିଲେ ବାରିକ ହଉ ଆପଣ କିଛି କାମ କରୁ ମୁଁ କେତେ କହିଲି ବୁଝାନ୍ତୁ ବୋଲି The petitioner submits that inadvertent typographical error has scripted to the petition as thus spelling of the petitioner number 1 has been wrongly typed as Ispita within quote instead of Ipsita. The cost title of the order of the learned Judge Family Court indicates the name correctly as Ipsita.
I have filed one.
C6 need to correct the name in the court today. Stop. Prayer is allowed. The necessary correction be carried out in the cost title of the petition, which shall bear the initial of the learned counsel for the petitioner. Upon correct query, signature to be countersigned by the court master.
I have filed on miscusement.
Sorry?
I have filed on miscusment.
Whenever, madam, you are challenging maintenance for enhancement, don't seek stay of that order. You should pray that let her continue to receive that without prejudice.
Stay of
Suppose after the stay କରିଦେବେ, the entire amount is stayed.
ନା ସେଟା କହୁନି ସେଟା ହଉଛି ସିପି ସେ ଫାଇଲ କରିଛି ତ ଡାଇଭର୍ସ କେସ୍ ଟା ସାଙ୍ଗେ ସାଙ୍ଗେ ବିଦା କରିଦେଇକି ଡାଇଭର୍ସ କେସ୍ ଫାଇଲ କରିଦେଇଛି ତ
ସେଟା stay ହେଇପାରିବ
ନା ଏଥିରେ ବାଧ୍ୟ କରୁଛନ୍ତି ତମେ ଏଟାକୁ ସାରା ଆଗ ବୋଲିକିରି
ବାଧ୍ୟ ହେଇପାରିବ ବାଧ୍ୟ କଲେ ସେଟା ପିଟିସନ ଦେବେ ଆପଣ ଯୋଉ ଅର୍ଡରଟା ବାଧ୍ୟ କଲେ ସେଇ ବାଧ୍ୟତାଟା ଏଠି ଚ୍ୟାଲେଞ୍ଜ କରିବେ
କରିଛି ଏଟାକୁ
ବାଧ୍ୟ କାଇଁ ବାଧ୍ୟ ଅର୍ଡର ଦେଖାନ୍ତୁ କୋଉ ଅର୍ଡରରେ ବାଧ୍ୟ କଲେ
ନା ଅର୍ଡର ଟାକୁ ବାଧ୍ୟ କଲେ
ସେମିତି ସେଟା ଆଜ୍ଞା ଓରାଲି ବା ଗେସ୍ ୱାର୍କ ରେ କରିହବନି you must understand that this court acts with a jurisdiction
ଆଉ ଗୋଟେ ପିଟ୍ସ କେସ୍ ଫାଇଲ କରି
this case ଆଉ ଗୋଟେ ହବନି maintenance matter ରେ main case stay ହେଇପାରିବନି
ସେଇଥିରେ ସେମାନେ ବାଧ୍ୟ କରୁଛନ୍ତି ଆଗ ଏଇଟାକୁ
ବାଧ୍ୟ ଆଜ୍ଞା ହେଇପାରିବନି ବାଧ୍ୟ କରିବେ କାହିଁକିନା ଦ୍ୟାଟ୍ସ ଆମେ ତାଙ୍କୁ ବାଧ୍ୟ କରୁଛୁ ଡିସ୍ପୋଜ କର ତାଙ୍କୁ ସୁପ୍ରିମକୋର୍ଟ ବାଧ୍ୟ କରୁଛି ଯଦି ଆପଣ ଆଡଜର୍ନମେଣ୍ଟ ଆଲାଉ ହେଇନି କି ସେ ରିଜେକ୍ଟ କଲେ ସେଟା ଅଲଗା କଥା
ସେ ବି
କେସ୍ ଡିସ୍ପୋଜାଲ ଆଜ୍ଞା କେସ୍ ଫାଇଲ ହେଇଛି ମାନେ ବାଧ୍ୟ କଲେ କେମିତି ହବ
ସେ ତାର
ଯେମିତି ଏଠି ଆଡଜର୍ନମେଣ୍ଟ ନଉଛନ୍ତି ମୁଁ ଦେଇ ଦଉଛି ସେଟା କଣ ହବା କଥା କି ସେମିତି ହବା କଥା ନୁହେଁ
ସେ ତାର ବି ଅପରେସନ ହବ ବୋଲିକି ସେ ମାଗୁଛି ସେଥିରେ ବି ସେ ମନା କରୁଛି
ସେଟା ଓରାଲି ହୁଏନି ମ୍ୟାଡାମ ଆପଣ ଯାହା କରିବେ ପିଟିସନ ଦେବେ ପିଟିସନରେ ଯାହା ଅର୍ଡର ହବ ଯଦି ଇଫ୍ ୟୁ ଆର୍ ଆଗ୍ରି କମ୍ ଟୁ ଦିସ୍ କୋର୍ଟ I cannot second guess. The Court of London, the Family Court, Jajpur does not allow adjournment. Possibly, I am not disbelieving, but I cannot second guess it by not having records, material on record. You must understand that this court, I don't have the original side jurisdiction. Trial court has, Family Court Act, trial court is authorized. That's a judge family court. Suppose you are filing an application. The order is passed which you are aggrieved. That you have to challenge, not in maintenance. Correction here. The petitioner wife is before this court seeking enhancement of the maintenance granted by the London Judge Family Court in IA number 03 of 2026 arising out of CP number 373 of 2025. The IA was filed by the wife in the marriage and the minor child born from the wedlock in the CP. The CP having been filed by the husband in the marriage seeking dissolution of marriage and the grant of decree of divorce. So, the application for pendental light maintenance under section 24 of the Hindu Marriage Act was filed seeking 40,000 for the wife and 20,000 for the child, and 50,000 as litigation expenses stuff. The application, the IA was favored, but an amount of rupees 10,000 has been directed to be paid to the wife and 5,000 to the child. So, it is submitted that the amount directed to be paid as maintenance, considering the income of the opposite parties, husband in the marriage, is meager or is less. Stop.
and that has not been challenged.
Issue notice along with this order. Issue notice to the opposite party along with this order. Requisites for issuance of notice shall be filed within. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 5 working days.
By Friday.
List returnable date be fixed to.
Action for
25/6/2026. Matters shall be listed in the week commencing 6/7/2026. It will be 13/7/2026. So, it is further directed that the petitioners in the present application shall continue to receive the amount towards maintenance without prejudice to their rights and contentions in the present writ application. Yes. आईटा कौन डिसमिस कर देबे ना नहीं से थिबो सेम
liable.
ठीक है था आइए था सिलेक्ट करो यस नेक्स्ट प्लीज
15,
पासओवर फ्रेश एडमिशन की आसिले अतरे मुरु कॉल कर
There for item 11.
मिस पटनायक विल बी डूइंग दैट आइटम
Yes, ma'am.
ओके आपण कॉल करंतु
Pachover item 4,
तापर नेक्स्ट
item 6, 9, 11,
May I please, Your Lordship? My lord, in this case, the petitioner is the wife. My lord, she had filed a divorce.
नायक फॉर द petitioner opposite party black yes miss patna
No, the petitioner wife had filed a divorce on grounds of cruelty and harassment, my lord, after
Yes.
4 years of marriage.
yeah
My lord, subsequent to that, in the counseling reports, everything, my lord, she had categorically denied going back to her husband, and that there was no scope of resolution.
yeah
But my lord, pursuant to that, the husband filed a Section 9 petition. For
Not pursuant is the wrong submission. Section 9 cannot be filed pursuant to a 13 application by the other party. Section 9 is independent. The section is independent itself. Okay, the husband has filed Section 9.
Section 9.
That has been allowed.
That, my lord, for that the wife had filed a rejection of Section 9 application after filing of the Section 9 petition. My lord, on that the learned lower court has heard the matter and has ordered for analogous hearing.
Has to.
My lord, my submission is that once the wife has denied.
No. Must understand. You talk to your senior. Section 9 is an independent suit.
Yes, my lord. Section 9 is.
Section 9. Who is the dominus litus?
My lord, your lordship is correct, my lord.
No. Lordship is maybe absolutely wrong. You must understand what you are saying. You are being watched. You
Yes,
must understand. People are watching us. You are saying that one suit should be rejected in limine. Dismissal in limine of a suit cannot be. It has to be on trial. So there has to be analogous hearing. That is the stance law.
my lord, my submission.
So when Section 13 is filed, Section 9 is filed, you want dismissal of Section 9, it has to be contested. Not without contesting by filing of an application. For contesting a Section 9 application, you have to file written statement. Issues have to be framed.
My lord, we have filed a written statement.
Correct.
We
So
have
both
contested the statement.
Correct. So now 13 and 9 has to be taken up together. The court doesn't have a choice.
My lord, there is a decision of this Honorable High Court.
Supreme Court. High Court may have decided wrongly because there are several decisions where it says that there has to be analogous hearing of Section 9 and 13 application. So when you are saying that Section 9 to be heard separately and it has to be dismissed in limine. Actually, when you are saying that you have filed written statement and whether the issues have been framed, evidence has been adduced.
My lord, we have filed a written statement. We also filed the application for rejection of Section 9. After that, the
rejection, you see, you must read CPC. When the plaint can be rejected by a trial court, not at the instance of the defendant. It cannot be. There are certain conditions when plaint can be rejected.
this
Can be
Honorable
possible.
This Honorable High Court had laid guidelines in Sanjukta Patra versus Gyanaranjan Padi.
Is it a single bench or a division bench?
It's I have not
You examine it.
annexed the order.
It's a if what you are saying is correct, then the order is palpably wrong. High Court, our High Court does not do pass such orders. I am confident. In many matters, our High Court has correctly interpreted the law.
But
Section, what you are saying is something different, and High Court. Do you have the judgment? Have you seen the judgment to say
yes,
that?
my lords, I've seen the judgment. I don't have a copy.
Show it to me.
Your lordship, I don't have a copy of the judgment.
So just simply adjourn.
Yes, your lordship.
After hearing of the matter, the petitioner wants adjournment to make further, to address further. Stop. List in the week commencing. Chutti pare na purvuru.
Lordship. Lordship,
Commencing 18/5. Yes, next.
Lordship, it's a single bench order. Just.
But no judge will make this kind of observation. What you are saying.
No, the observation.
That the 9 has to be dismissed without going into.
There is guideline for
Guideline. The Supreme Court has already decided.
Your lordship, I'll appraise.
This High Court cannot go beyond CPC while issuing the guideline.
Your lordship.
Those guidelines cannot be.
Oblige, your lordship.
Yes. There is no such provision in Family Courts Act or CPC that Section 9 has to be dismissed.
No, my
much less I can issue guideline. Like even if it is a division bench.
No.
Next.
Item 30.
You are making a fabulous argument that IA cannot be entertained. The REIT is not maintainable.
I'll appraise, your lordship.
For dismissal of a Section 9 during pendency of 13, This is unheard of.
Your Lordship, may I? Item
You
13.
check the provision in Hindu Marriage Act. It's not like it is a very small, few sections, but it is completely covers everything. There is a provision, specific provision in, I think, section 26, where you can also raise this as a section 9 can be a counterclaim by the husband in your 13 application.
Yes, Your Lordship.
You can have your 13 as a counterclaim in the 9 application.
We have.
So if that is the provision, then how can the court direct to dismissal of section 9?
Lordship,
It is neither in context or proper prayer in the, as far as scope of Hindu Marriage Act is concerned.
Lordship, my limited prayer was if the wife is subjected to cruelty and harassment and she has
That is your defense in section 9. You must understand.
Yes, Your Lordship, we
So
have
you
filed-
taking a defense, you are saying everything yes, then why you are making an absurd prayer?
Lordship,
If the wife's section 9 prayer is for says cruelty is the defense, then you are, unwittingly or purposefully you are supporting section 9 application to be rejected. So that is to be adjudicated by the court, not in limine.
Lordship, I'll get the judgment on the next day.
There is no such judgment. Did you go to the AI to search for this?
No, Your
So
Lordship.
don't rely on that.
No, Lordship, I have the judgment.
There is no such judgment that section 9 has to be dismissed when 13 is filed.
Lordship, on next date.
Have you checked the provision under which you have filed a dismissal application, rejection of plaint? What is the provision? ଆପଣଙ୍କ ପିଟିସନ ରେ ଯୋଉଟା କଷ୍ଟ ଟାଇଟଲ ଲେଖିଛନ୍ତି, you take your seat.
Yes, Your Lordship.
Lordship, annexure.
अरे annexure नो सीधा provision टा कौन? वो provision रे फाइल कले rejection application टा, rejection of plaint.
Petition for dismissal.
वो provision quote करछन. That is the problem. When you do not refer to the law, that is the problem.
My Lord, at page 35, they have referred to the
What
judge.
page 35, which provision of any family court act or CPC, you have filed application for rejection of section 9 petition. Which provision?
That's in provision. They have not filed on any.
So
provision.
they are, so don't follow them. They are really bad in pleadings. You should have asked this question to your learned colleague at the, who is appearing there. These headless petitions are not to be entertained by court.
Lordship, ଗୋଟେ date को रखो मैं खाली
No, I am not disposing of. I am just asking you because you are so badly prepared and you are making outlandish proposition that when section 13 is pending, section 9 should be dismissed without there being trial. So how could you formulate such points? For a young counsel, this kind of confusion should not be there. It is better not to know, but to know the wrong things is a problem for a lawyer. A ବହି ଆଣିଛି ବହି ବି ଆଣିନାହାନ୍ତି 23 capital A ଦେଖନ୍ତୁ
Lordship,
23 capital A ପଢ I have a purpose in spending time with you because
Lordship,
when we start practicing, when these kind of complete absurd proposition 23 ଟା ପଢନ୍ତୁ just ପଢ ପଢ
relief for respondent and divorce and other proceedings. In any proceeding for divorce or judicial separation or restitution of conjugal rights.
Stop there. So all three have been covered. 13, 9, yes. Then read further.
The respondent may not only oppose the relief sought on the ground of the petitioner's adultery, cruelty, or desertion, but also make a counterclaim for any relief under this act on that ground. If the petitioner's adultery, cruelty, or
So
desertion
leave
is
it
proved,
there. So any you can claim relief also.
Your Lordship,
So that is completely opposed to what you are contending.
Your Lordship, I bow down out. I
No,
just realized.
bowing down doesn't help. I can bow down also. But what you are saying, it is in fact beyond absurdity. It is not bordering absurdity. That because you have filed a 13, so 9 has to be dismissed. Give the book. Because when you start arguing absurdity, you prepare an absurdity. and start imagining things, start imagining decisions. There is a decision, and you file application before the trial court without referring to any provision, either Family Court Act or Hindu Marriage Act or CTC. You must understand, trial court is bound by these, not even a writ court also, or an appellate court like me. I am exercising 227. I am not exercising 226 also. I have to follow that. Then this kind of interpretation will lead to 23A being rendered OTOs. Yes, next. Yes, Ms. Rajgaria. Rajgaria for the petition.
Yes, Your Lordship.
Your
Lordship.
Plan.
Your Lordship, the petitioner has filed this petition for the expeditious disposal of the restitution case pending before.
Expeditious, unless you file affidavit that no other case is pending prior to that case, so then it cannot.
I will file the affidavit on the next very date.
How do you know?
Means, my lord,
Suppose that this is a case of
restitution of conjugal rights.
23. Prior to 23, no case is pending in that court.
To that effect, I will file an affidavit.
Have you read the Constitution bench decision?
No, my lord.
So this prayer cannot be granted.
No, I need some time, my lord, just to file some important documents because her.
Filing of important documents will not help the prayer. You must read that. If you want, I will give you the decision now and you will read it.
Yes, Your Lordship, but I need some time, my lord, because for adjournment.
Cannot keep this matter pending.
Your Lordship, I
It's been
need.
injuncted by the Supreme Court. You must
No,
understand.
I understand, Your Lordship.
So your understanding and my understanding are converging.
No,
I
no.
cannot keep the matter pending.
My-
Petition prayer is made for expeditious disposal.
No, my humble submission is that, my lord, her mother is, her grandmother is in deathbed. So I am just
Cannot
submitting.
be a ground for expeditious disposal. So
For the last 3 years, it is pending, my
3
lord.
years or 30 years, the question is very simple. If any other matter is pending prior to 3 years, then it cannot be taken up expeditiously. Then the only thing is that
Any other matter relating to this part, these parties.
you read before you submit, develop a habit of reading. Achhi pause. Copy ho Allahabad. Allahabad photo read. Read para 41, 42, 43.
Yes, sir.
Disposed of. Yes, next.
Lord,
Constitution bench
single,
cannot-
one single adjournment may kindly be granted, Your Lordship.
adjournment adjournment which will not serve your purpose should not be granted because it creates the impression that you are doing something worth, like the last matter. She argues that section 9 has to be dismissed.
No, that is not.
Please appreciate. And now what you are making is expressly prohibited by Supreme Court.
Yes.
So that I cannot keep it pending. I cannot, because yesterday I disposed of 3. Today I have to dispose it of. Because that adds to pendency for no reason.
There are two matters, my lord. The husband has also filed a divorce petition. Both are tagged, clubbed. So, sir, I am not.
You must understand the law, read, then you can understand.
Yes,
You
yes.
are struggling because you have not read the Constitution bench decision. I'm passing it over. Upon you take your seat and read.
Obliged.
Passing it over. 41, 42, 43, Podoltu. Yes, next.
Item 15.
Pass over kar
16.
Pass over.
17.
17 will make legal.
Yes.
I have already filed the complete requisite, my lord, but noting is that, my lord, issuance of press notice to OP could not be issued due to.
Verify କରିବାକୁ ପଡିବ ଆପଣ ଟିକେ check କରନ୍ତୁ
मुझे check करते.
Mr. GN Sahoo for the petitioner 17. Office note indicates that complete requisites for have not been filed for issuance of notice. As directed by order dated 9/4/2026, the Lord Counsel for the petitioner has adjournment to verify and do the needful. How much time? 1 week time. For which 1 week time further time is granted. Yes. Upon filing of the para, upon filing of the complete requisites, notices shall be issued to the opposite party. देखी दिंतु कौन आपण बड़े बड़े क्लर्क सेटा कौन मिस कर जेथान
नहीं
देखी दिंतु. Yes. Next.
18.
Item number 18, Your Lordship, I'm appearing on behalf of Mr. Das.
18, yes.
I'm appearing on behalf of Mr. Das. During the last occasion, we are supposed to receive the rejoinder.
You are for the petitioner or the opposite party?
Your Lordship,
We
I'm
are for the
You are for the petition. Okay.
Yes,
What's your name, madam?
Mona Lisa Ghosh.
Mona Lisa?
Ghosh.
Mrs. M. Ghosh for the, on behalf of A. Khan for the petitioner. Mr. You are Mr. Your name, sir?
Ronak Panda.
Ronak Panda. So, R. Panda on behalf of A. Das for the opposite party. Rejoinder file karibe.
Your Lordship, I'm praying for 2 weeks time to file rejoinder as well as objection.
18. The state party. Chairman PLA.
Yes, ma'am.
Mr. Additional Standing Counsel, Prabhu Prasanna Behra, Additional Standing Counsel for OP1. OP2 by Mr. Pondale. The Lorded Counsel for the petitioner refers to the earlier orders dated 24/2/2026 and 6/4/2026 and submits that she may be accommodated for the petitioner may be granted for the time. The petition may be granted for the time to file rejoinder. As prayed for, the matter shall be listed in the week commencing. Date 6/7/2026. Rejoinder will be filed within 3 weeks upon serving copy thereof on the Lorded Counsel for the petitioner. Yes, next.
19,
19 the mention is like 19 upon also.
Yes, sir. For the opposite party.
19 yes. You are Mr. Atmajit Manmat Das.
No, Millers, in item 18, I was held in another court. I'm for the opposite parties.
Did the appear column? Upon associated with the appeal column? Upon Mr. Anupam Das.
Millers, I'm on behalf of Mr. Das.
Upon Gonago.
S. Sharma. Shubham Sharma.
Then Mr. Shubham Sharma, other than Mr. Ronak Panda. Dijon elected. 19 re. Miss A. Das. Miss I. Misra.
Yes.
So, Nahanti kon pora galen. Kon kore. 2 weeks time dawa. Petitioner none. Pore asile jodi asibe koibe de debe. 19 petitioner none. Miss I. Misra on behalf of Arjit Misra for the opposite party. Office note indicates that certified copy of the impugned order has not been filed and staff reporting could not be made. Stop. The matter is kept pending since 2022. Stop. To grant further opportunity to the petitioner, 2 weeks time is granted for filing of the certified copy of the impugned order. The matter shall be listed for admission in the week commencing 18/5/2026. Copy of this order shall be communicated to the Lorded Counsel for the petitioner by the registrar. Yes. Upon Janchandi, petitioner counsel को. ठीक है. Can inform actually.
item 21,
20 time Arjun mentioned it. 21 Mr. Mahapatra was there. पढ़ेले. पास ओवर कौन था?
23,
Mr. Ajit Kumar Ratha for the petitioner, opposite party. Mr. Ratha, you were saying fresh steps नहीं लेना, कौन करिए?
That has been returned back with a memo of that the address is left. The address.
Sir, if there land acquisition matter है notice sufficient knowledge that becomes a problem. Because it is a right to property. तो अपना fresh discover करिए पे time नहीं हों तो I'll grant you sufficient time. but I can't proceed by recording that it is sufficient. Technically, kari hobo. You know, there are some decisions technically kari hobo, but I don't think it will yield any result.
That's one.
Okay?
That's it.
How can compliance achi? Mr. Nath Patnaik ki? Mati achanti? So Ajit Kumar Atha for the petition, Mr. Prabhu Prasanna Behra. Mr. Behra, you are there?
My lords.
For the OC number 1. 22. The office note indicates that the service has not been sufficient on the opposite parties to the other opposite parties. The opposite parties to some of the opposite parties. Some of the opposite parties. The registry shall, the concerned superintendent shall prepare a shall indicate clearly in the office note who has been served out of the 3 respondents, where from whom the notices have been returned answered, and if fresh steps have to be taken. Stop. The learned counsel for the appellant has liberty to find out the present correct address and take steps for issuance of notice affairs, for which 4 weeks time granted. List matters shall be listed for orders in the week commencing. 13/7. Yes.
Item 24. I am for the opposite party number 8 to 12. Just one faster.
That's an item 24. I am for the petitioner.
Mm-hmm.
And our senior has given the counter in the I request some more time to file the rejoinder.
Counter ଆପଣ counter fail କରିଛନ୍ତି?
ମୁଁ counter file କରିଛି।
ଟିକେ appearance ଟା ଟିକେ ଦେଇଦେବେ ଗୋଟେ କାଗଜ ଦିଅ।
ଆଜ୍ଞା।
ଗୋଟେ କାଗଜ ଲେଖିବେ।
Senior counsel.
You are Mr.
G. Mohanty.
Mr. G. Mohanty for the petitioner.
ମୋର ପିଟିସନ ଟା ଅଛି ଆଧିରେ ଗୋଟେ ମୁଁ ଫାଇଲ କରିଛି ଇଣ୍ଟରିମ୍ ଆପ୍ଲିକେସନ ଟେ for vacation of or modification of the order.
Sir, vacation is very difficult without hearing.
Sir, ସେଇଟା
You
କହୁଛି।
must understand. You must understand that ଆପଣ this has to be heard as for admission matter. Orders ରେ I cannot simply vacate.
ନାଇଁ ସାର୍ ମୁଁ କହୁ ନଲେଜ କୁ ଆଣୁଛି ସାର୍ କୋର୍ଟ ଆଣିଲି।
ମୁଁ ତ ସେ knowledge କୁ ଆସିଲା ପରେ ସେଥିପାଇଁ ଆପଣଙ୍କୁ କହୁଛି।
ସିନିୟର ଅଛି।
My lord, we have filed an application for recall of the order or modification of this order, my lords, which has been passed by this honorable court, wherein, my lords, if your lordship sees the order dated 23/9/25, this is the order we are seeking recall for, because by virtue of this order, my lords, no elections are being held for the last
So I was just informing Mr. Jetty that you saw this copy of the IA. Let it be heard along with the counter to the main writ application.
Served since August
it has been served since August, my lord.
Counter file is ସମସ୍ତେ କଲେ।
Minutes. We have filed counter minutes.
Counter ବି ଫାଇଲ ହେଇଯାଇଛି।
नहीं ଆପଣ ମାନେ petitioner जे ଆପଣ
Rejoinder file.
फाइल करना है
No.
IA रे objection
No. That also we have not filed. But your lordship may keep it to some other
August
time.
2025 ରୁ ସାର୍
August ରେ ଆପଣ पर ନେଇଛନ୍ତି କପି କହୁଛନ୍ତି।
Copy has been served since 2025.
ଆଇ ନମ୍ବର ଟା କେତେ?
ଆଇ ନମ୍ବର ଟା 244
22,141।
yes ma'am
Yes, ma'am.
flag 22141
Flag C
22141
हाँ 22,141। এটা তো ডিসেম্বরের, এটা অগস্ট নয়।
December.
Ah, yes,
এটা
yes, this one.
ওকে
8/12/2025.
appearance লিখিলি ଆଜ୍ଞା ପିଟିସନର ଲେଖିଲେ ତାପରେ ଲେଖିବେ ମିଷ୍ଟର ସିନିୟର କାଉନସିଲ मिलन कानून को along with Mr. Sushant Kumar Jethi for OP number only for
8 to 12.
8 to 12.
is 8 TO to 12. तापर लिखिए the additional standing counsel. So Prabhu, you are here.
Yes, ma'am. I filed the counter.
Person where additional standing counsel OP number 1 to 7.
1 to 8, 7. ma'am.
7.
The learned senior counsel refers to the IA. The counsel for the learned counsel for the petitioner submits that he may be accommodated further to file rejoinder on behalf of the petitioner in response to the counter filed by the states. अपना कोई भी rejoinder file करना है?
No.
Counter filed by states OP number 1 to 7. अपना को भी counter
Our- No, sir. I'm a counter नहीं दी जो.
हमें counter दे
File rejoinder to 1, the counter filed by OP 1 to 7 and counter of OP 8 to 12. 12. Stop. The learned senior advocate appearing for OPs 8 to 12 refers to the IA number 2241 and submits that prayer has been made for modification
stroke recall.
stroke recall of the order dated 17/25. Passed by the coordinate bench. The learned senior counsel presses for hearing of the IA. In considered view of this court, the matter needs to be heard finally. Upon कितने दिन फाइल को complete करियो pleadings?
Not 2 weeks time.
The pleadings
Malats, may I?
behalf of the parties shall be completed within 3 weeks. The matter shall be listed for fresh admission. For admission. For admission in the week commencing 13/7/2024.
Malats, may I just submit for the self-same cause of action, he has filed a civil suit. And by virtue of this order, he has been continuing for the last 17 years, he has been continuing without elections. This was passed in 25. He is re-endorsing. An illegality is being allowed to be perpetrated.
17 years, now 1 year. 18 years. This court is responsible for 1 year.
Well, I understand.
So, I mean, that's a very valid legal strategy. So, what can be done? So, I mean, lawyers are innovative.
No. I understand.
Today, you must have heard the young lawyers. It is the argument is that one section 9 is filed after filing of 13 by wife. I'm just giving an example. I mean, not finding any fault. One interesting proposition. 9 has to be dismissed. So,
No.
and in one constitution bench, this the senior must tell the others. Asian is surfacing asila. It is reaching 100. So
My lords, if
unless
you-
you take up the orders and fresh admission matter,
My lords, may I pray that on that date, your lordships, I think, have fixed it up on 17th.
13th, 13 week.
13 sir. Can it be taken
13
up?
Saturday ଆପଣଙ୍କର ତ ଏଇଟା just third week after the reopening ଆପଣ 6-7 କରିପାରିବେ
13 7 ବି ଠିକ ଅଛି।
ଠିକ ଅଛି but liberty to mention I cannot say that I will take out of turn.
I'll have liberty to mention, my lords, because we want this matter to be over, my lords.
Yes,
It has to be heard by your lordship. Or
But
if it,
complete your pleadings. This plea of lingering the
By
matter
that time, by that time.
so valid, legally valid strategy, but please 17 years you are continuing. Yes.
Yes, here also we have instructions. Matlab, subject lordship permits me to submit. Matlab, here because of this pendency, matlab, several law and order situation, and the other members are filing several complaints because matlab, this self.
But that will attract that article failure of machinery. President should not କଣ ଆପଣ ଚାହୁଁଛନ୍ତି?
What has happened?
ଆପଣ ତ ସେଠିକି ପଳେଇଲେ।
No,
ମାନେ ଏଇ ମାନେ ହିଁ law and order situation ଆପଣ ଅଛନ୍ତି create ହଉଛି। ଠିକ ଅଛି।
because of that, because the self-same petitioner has filed a civil suit claiming that other members should not interfere in the functioning when the ADM has
It is very lucrative, it seems.
and the same petitioner comes here and says that is civil. So, my lords, there is intersect dispute between the
liberty to mention that ଲେଖା ହେଇଛି ଲେଖିଲେ ତ last liberty to mention.
deeply obliged.
interim order.
Interim order as passed earlier shall continue till the next date.
Deeply obliged.
Sub item ରେ କଣ ହବ Mr. Mahanti? ଦିଟା sub item ଅଛି।
One is a dispute.
ଖାଲି one line order to be listed along with
along with.
Okay. WPC 2266 of 2024. The matter is listed along with WPC number 25952 of 2025. In view of the order passed in the WPC 25952 of 2025, the matter shall be listed for admission in the week commencing 13/7/2026. Liberty to mention.
Obliged.
Interim order also said it.
Same interim order. 23998 of 2025. Same order. Listed along with charges. Yes, next please.
25.
Yes, madam. Did you go through that? Just one second. What a Passover plan.
Only my humble submission, but only in exceptional circumstance that.
So that exceptional, you see, the language used is very stiff.
I understand.
Language is very,
And so far,
as I was telling, I was sharing with the senior, the next matter, the court has said that what High Court should not do is doing every day. I don't want that kind of a comment.
I understand, my lord, but this is about to save a family.
What I am doing that last para. Suppose in case of a delaying tactics, CPC is very clear. Because my order, I am specifically asking that whether you have filed any application before the trial court stating that the other party is delaying, then what is the order passed? Then this High Court can definitely interfere. I mean, this court, the court in 227.
In this particular case, my lord, the opposite party is delaying actually for the last 2 years.
That 2 years you have to bring to the notice of the trial court.
Yes,
The
I will
trial
do
court
that.
has to pass order.
I will do
that paragraph I will add it.
Yes, my lord. And it is about to save a family only. That's why, because it is a
Sure.
section 9 petition, section 22 of Special Marriage Act.
Then take it.
Deeply obliged. Deeply obliged.
Let's separate the discourse of the what had a kitten number tonight? Terra number disposed of the targeting of. Yes. Yes, next. कल करो तो ये
25.
So Behra, Dr. Kumar Behra for the petitioner. Oh, sure. Typographical error.
Again?
एउटा कौन टाइपिंग भूल ହେଇଯାଇଛି
ନାଇଁ ସେଟା RPFM number ହେଇଥିଲା ତା subsequently it has been converted to GUAP. But
in 25 in order dated 25/3/2026 inadvertent typographical error has been crept in. The order number shall be corrected to be order number 3. instead of order number 2. Necessary correction be carried out as per this. Yes.
But petition of referral lawsuit is the husband. Multiple proceedings are pending between both. Divorce proceeding, she is not appearing despite notice.
Yes.
This guardianship petition also, she has not appeared.
What is the prayer in the application? GUF?
Only to give me the customer. My prayer was to take the custody of a child of the son of 7 years. Wife,
ସେ ଆପଣଙ୍କ ଫେଭର ରେ ଗଲା ନା ଗଲା?
ନା ମୋର ଏଟାକୁ ରିଜେକ୍ଟ କରିଦେଲେ. Even the wife has said expertise did not choose to appear.
That is not necessary. ଆପଣଙ୍କର appear ନ କଲେ କଷ୍ଟଡି ଦେଇଦେବେ ସେ ଆପଣଙ୍କୁ, ସେଟା ତ ହେଇପାରିବନି.
ନା custody ନହେଲେ ତ 7 years child, he should have brought to the court to give his opinion. Opinion
ବୟସ କେତେ child?
more than 7.
More than 7 ହେଲେ father ର custody ରହିବ, ସେଟା ନାହିଁ, ସେଟା ଭୁଲ interpretation.
Opinion, he can give opinion in court. That is
up to 18 opinion is not valid. Court may interview opinion in court 7 ପରେ କୋଉ provision ଆପଣ set କରୁଛନ୍ତି? Which provision?
17.
After 17 ସେଟା ଆପଣ, that's a wrong interpretation of that.
Provision section 7.
Minority Guardianship Act
17. Boyan. ଲେଖା ଅଛି.
Minority Guardianship. The border is open ଅଛି ପରା, ସେ border ଦେଇଛୁ ଏଟା. ଆପଣ minority and guardianship what questions?
Guardianship and what's maintenance proceeding, maintenance has been awarded in favor of wife and son. I am paying them.
Guardianship and what's act ଏଇଟା ଏଇଥିରେ guardianship what's act
Minority guardianship and what's guardianship.
ନୋଟିସ୍ ନିଅନ୍ତୁ, ଦେଖନ୍ତୁ.
ଆଜ୍ଞା
ଆପଣ ଇଣ୍ଟରିମ୍ ପ୍ରେୟାର କରିଥିଲେ କି ଭିଜିଟେସନ କଣ୍ଟାକ୍ଟ ରାଇଟ୍?
ନା 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 ସେଥିରେ ସେପାରେଟ ପ୍ରେୟାର କରୁନୁ.
ଡିଲେ
ସେତିକି ଦେଇଥିଲେ ବି ହେଇଥାନ୍ତା.
ଏଟା କଣ ଡିଲେ?
ଆଜ୍ଞା
ଡିଲେରେ ନୋଟିସ୍ ନେବେ ନା?
ଆଜ୍ଞା ଡିଲେ ଅଫ
counsel for the petitioner.
Delay of 23 days.
The petitioner husband and the petitioner is father of the minor child, seeks custody. They sought for custody by filing Guardian with case number 59 of 2023 before the Lord Judge Family Court Rourkela under section 7 and 17 of the Guardianship and Wards Act.
Okay.
Guardianship, no, the Guardians and Wards Act, 1890. ठीक लिखिए, भूल लिखा है. The child, the mother's opposite party in the said application has the custody of the child who is now aged, who was then aged about ସେତେବେଳେ ବୟସ କେତେ ହେଇଥିଲା?
ଆଜ୍ଞା
Date of birth of child 18. Then is it about then is it about 4 years? Stop.
7 years.
ଆଜ୍ଞା 18 ରେ 5 ମିଶିଲେ 23 ଆପଣ 7 କହିବେ ମ୍ୟାଥମେଟିକ୍ସ ବି ଭୁଲ କରିବା ମାନେ 18 ବର୍ଷରେ ଜନ୍ମ ହେଲା 18 ମସିହାରେ 23 ମସିହାରେ କେତେ ବର୍ଷ ହବ 7 ହେଇଯିବ 18 5 23
5 ବର୍ଷ
is it about 4 ବର୍ଷ ବି ହେଇପାରେ is it about 5 years? About 5 years. The petition of the husband seeking custody has been rejected by judgment dated
18 ରୁ 25 ହେଲେ 7 ବର୍ଷ
23 ରେ ଫାଇଲ ହେଲା ଆପଣ ପିଟିସନ ଆପଣ ଯୋଉ 26 25 କରିପାରିବେ
ଆଜ୍ଞା
ଦେଖୁ ବି ନାହାନ୍ତି
ହଁ ସେତେବେଳକୁ ଚଲେ 5 ବର୍ଷ
so it's by judgment dictated
judgment 16/7
it is submitted by the learned counsel for the petitioner that the husband the father as husband did not seek interim custody or file an application seeking visitation and contact rights. Stop. Issue notice along with this order to the opposite party. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 7 working days. Within 7 working days. List returnable date be fixed to fixed to 30/6/2026. List in the week commencing for orders. Matters shall be listed for orders in the week commencing 13/7/2026. Yes, next.
26
issue notice in the IA as well as the appeal. The purbo line likhibe the appeal has been filed after a reported delay of 23 days. Permission yes, next.
item 26
6 minutes no instruction lordship can dispose of
memo te diyo
ଆଜ୍ଞା
ଆଗରୁ hearing କେବେ ହେଇନି
ଆଜ୍ଞା ସେ my lord what happened here my lord 125 application rejected on the ground on the date of adjudication of the 125 application divorce has been granted. My lord, in the year of my lord 2013, in the meantime 13 years has been lost. My lord, no instruction received. ସେ ଯଦି ଆଉ ଗୋଟେ ବାହା ହେଇଯାଇଥିବ
permanent alimony ନାହିଁ ସେଟା
permanent alimony ବି ହେଇନି in the
divorce wife gets maintenance 125 is very clear
ଇଏ nullity declaration of nullity my lord my lord I cannot argue my lord complete picture my lord just now my lord ସେ ଯଦି ଆଉ ଗୋଟେ ବାହା ହେଇଯାଇଥିବ my lord I will be face problem.
The matter was presented before this court on 11/9/2013. Notices were issued on 23/9/2013. Thereafter, after appearance of the opposite party, the matter has not proceeded any further, as it has not been, as it could not be heard for the last 13 years. So today the matter is listed for hearing under the heading for admission. The counsel for the petitioner submits that the petitioner wife is before this court challenging the order passed by the order dated 1/8/2013, passed by the Learned Judge Family Court Quarter, rejecting the prayer of the wife seeking maintenance under Section 125 of the CRPC. Stop. They submitted that despite the efforts to contact, the petitioner remains incommunicado. The present status of the petitioner, present marital status of the petitioner of the opposite party is not known to the learned counsel. Stop. None appears for the opposite party when the matter is called. The opposite party is also absent on repeated call. Stop. The learned counsel for the petitioner files memo of date which states thus. Stop. The petition is disposed of. Accordingly, the petition is disposed of. Copy of this order shall be forwarded to the learned judge family court. Court will be kept in the records of CR P. number 641 of 2010 disposed of. 1/8/2013. Yes, next.
27.
Parents, Mr. B. Sahoo for the petitioner, opposite party to
Umarani Ponda. Miss Umarani.
Chocolate, sir.
My lord, in this case, ये कैसे आम केस रे अलगा
27 के मेंशन करते ले मिस्टर रे 28 so Dilip Ray for the petitioner
27
like 27
ये कॉपीटा मते अलगा कॉपी दीचंदु काउंटर ये काउंटर जो केस फाइल
you are there for the opposite party
आई एम ऑन बिहाफ ऑफ एससी रथ ड्यूटीज ऑफ पर्सन
आपन को ना सर
माने इस्राइल खान
so Israel Khan on behalf of SC Ratha for the opposite party ହେଲା काउंटर को फाइल ही नहीं बात
ना काउंटर कॉपीटा से दे नांती से भूल को नंबरटा देचंदी ए नंबरटा केस नंबर होची
the matter is listed for hearing under the heading for admission. The office note indicates that pleadings have not been completed. The parties have completed their pleadings and exchanged the same. How much time?
सर ये
3 weeks or 4 weeks?
सर काउंटर कॉपीटा जो केस दवा था देन नदी आउट कोर्स रे कॉपी देला
Coach sir गोटे मते इंटरप्ट करंतनी because I have to dictate and somebody is taking down. मो बुझू छी सर ठीक है pleadings जहाँ आपण को करिया कथा you are satisfied with the pleadings ना कारण लिखा है जे no such counter is filed 3/25 बस से देखिना मिस्टर रे ताको आपण टे देखा तो
ए लिखा है तीनों दे petition no such counter is filed काउंटर फाइल करनु ई अच्छा 12 ऑफिस देई देखो ना एनालॉगस में सर जोड़ा हितला था सी तो से
तेरा एनालॉगस कोन सर ऑर्डर है जी काउंटर फाइल इज विल ऑफिस नोट देइछंती 3/25
डबल पीसी नंबर 6 one next day
3/25 रे काउंटर इफ एनी shall be filed in the meantime
3/25 काउंटर सुना कानी after 2 weeks the conducting counsel counter देले मो तो रिजल्ट साथ
किंतु नोटिंग अछि जे काउंटर फाइल बा जति आपण आगुरु काउंटर फाइल करथिबे गोटे मेमोटे देबे जे दो इट इज डायरेक्टेड बाय ऑर्डर डेटेड टू फाइल काउंटर एंड it is already filed on so and so date ताले सेटा अप्लाई हे जिवो because 3 now is a judicial order must understand
not
if not already completed till date so it is submitted by Mr. Ray that he may be provided with a copy of the counter in the present writ application. He submits that he has received copy takudu paichindi na card agudu anchindi ka apana
sir takhu deichindi je she
feri diyondu
feri debi sir
ha he submits that he shall return the counter copy of counter filed in WPC number
ना ये जो केस है ये भी हम पक्ष फाइल कर छथि से भी काउंटर दे से केस रे ये केस देना खाली कहू ना मो कॉपी देछि बोली देना ये जो कॉपीटा मते
how interesting story for it today is the day for interesting stories माने आपण ए कॉपीटा आपण होचंदी पार्टी
এই जो केस रे
এটা সেতিরে রাখন্তু
हां
अब फेरे देबे काई कहू
ना এই केस रे
কিন্তু आपण কথা সিরিয়াসলি নাই কইলে ফেরে দেবে বলি
না স্যার এইটা এই কেস রে এই কপিটা মতে দেলে
with a copy of the counter affidavit another copy of counter affidavit Mr. Khan is saying he appears in so many cases you are the opposite party से out a case counter से appear करछन नै कि एक्शन दे
yes lord से बुझी सालिन
ठीक है list for admission in the week commencing 13/7/2026 yes Mr. Ray kindly help करो दोस्त ସେ ଜାଣିନାହାନ୍ତି ଯେ ଆପଣ କୋଉ କେସରେ କଣ କାଉଣ୍ଟର କହୁଛନ୍ତି।
ମୁଁ ତ ବୁଝେଇଦେଲି ଯେ ଆଉ ଗୋଟେ କେସ୍ ଦେଇଛନ୍ତି ଆଉ ମୋର ଏଇ କେସଟା କପି ଦେବେ ସେଟା ସେ କହିଲେ ହଁ ମୁଁ ଦେଇଦେବି ସାର୍ ଦେଇଦେବି
Yes.
obligation.
Yes, please.
Item 30,
Mr. Misra, somebody adjourned the matter. I told that he should inform you. He has not informed. Your matter, item 29.
Yes, madam.
କିଏ ମେନସନ କରିଥିଲେ ଆପଣ ମାର୍କ କରିଛନ୍ତି? ମୁଁ ତ ମାର୍କ କରିପାରିନି। Usually I mark, but I have missed it.
Simran Mike.
Mr. Adya Siddhi Misra for the petitioner. Opposite party, somebody mentioned actually.
Opposite party, if somebody has mentioned, they had not informed me.
So they said, I know. That is how I'm telling you. They say that I am informed, but
Okay, let it be.
okay. 13 को जाके छाड़ दियो।
Pancho.
Yes.
30,
The petition, the matter is listed for admission. ताले कौन के नांती ताले ठीक अच्छी. After yes, madam.
If your lordship permits me, I have a small prayer.
Yes, please.
In that case, item 13, my lord, if such a application is made before the learned trial court, that may kindly be considered. That much.
No, that paragraph is there.
Yes.
Paragraph
That much may kindly be reflected.
Because the concept is that if somebody is not cooperating, the CPC is very clear. When the petitioner appears, defendant doesn't appear. Defendant appears, petitioner doesn't appear. That has to be there. But what I find as a practical purpose, in some cases, my client doesn't appear.
Yes, your lord.
Or he doesn't cooperate with the lawyer. So lawyer doesn't have a choice. In some cases where I am the defendant,
Yes.
the other side, they take time.
Yes,
So
that is happening.
It's kind of a reciprocation.
Yes, your lordship.
You will say that why these applications are not filed. Technically, applications should be filed. That's a different thing. So that observation is there. One paragraph is there.
I am deeply grateful, your lordship.
Yes. But to save time, actually, I am only just because I could not bring that copy. To only to save time, I told you that I'll pass that on.
Yes, your lordship. Deeply obliged.
You are making any mention?
no, no.
Yes.
Passover matters. After
Yeah, kohibe. Because I have called twice.
Madam.
Not to be that three times, but I'll adjourn them. No difficult. Okay. So, ଆପଣଙ୍କର କୋଉ ଜାଗା ଅଛି କୁହନ୍ତୁ? ମହାନ୍ତି
Madam, 9, item 9, madam.
ଆପଣଙ୍କର ନ ହେଲେ ହେଇଯିବ। Not a ଲେଖନ୍ତୁ। No, I understand. But I can't keep you waiting for the other side to appear. Item 9. ଆପଣଙ୍କର 4 ବି ଆପଣଙ୍କର?
Yes, 4 is. 4 I am not asking.
ଆଚ୍ଛା 4ଟା ପ୍ରାଇଭେଟ ପାର୍ଟି। ଆଚ୍ଛା ଠିକ ଅଛି। 6ଟା ବି ଆପଣଙ୍କର ନୁହଁ। 6ଟା ବି ଷ୍ଟେଟ ନାହିଁ।
State, no.
9ଟା। Now ଲେଖନ୍ତୁ non appears for the petitioner though the matter is called thrice over. Once when it reached and thereafter on 2 occasions. And thereafter twice.
Lordship.
After about an hour. ହେଲା ଏତେ ନାଁରେ ଲେଖିବେ petitioner none Mr. P.K. Mohanty additional standing counsel for the opposite party to grant further opportunity to the petitioner list in the week commencing କରନ୍ତୁ 29/6 Mohanty 29/6 ଆପଣଙ୍କର ପାସ୍ ଓଭର ହେଇଛି ମିଷ୍ଟର ସେଠି କିଛି?
Your lordship, 15 and 16 for Prabhu Prasad. Pass over ହେଇଛି, your lordship.
ଠିକ ଅଛି ନନ୍ ଆପିୟର୍ସ ଆପଣ 15 କେତେ ଥର କଲ୍ କଲେ? 2 ଥର ସେ ବି 3 ଥର ହେଇଗଲା ସେମ୍ ଅର୍ଡର 15 ଆରେ ସେ ପିଟିସନର ଚାଲିଗଲେଣି ବୁଝିଲେ 16ଟା
Your lordship.
what we were guessing because she was ailing she suffered from the dreaded disease so she has passed away but 15ଟା ଲେଖନ୍ତୁ same order as now the matter is listed for orders non appears for the petitioner though the matter is called thrice over once when it is and thereafter for after half an hour for the second time and thereafter again half an hour for the third time Here petitioner none, Mr. Prabhu Prasanna Behera for the state. Private party by किए हम कोई तो कि तो नथिले तो बारीक 15 किए थिले 16 petitioner none. The petitioner was appearing in person. इतने भी प्रभु प्रसन्न है ना प्रभु प्रसन्न बेहरा होचंती एडिशनल स्टैंडिंग 16 रे मिस्टर प्रभु
Yes, sir. Okay. 15 and 16.
opposite party. None appears for the petitioner, though the matter is called thrice over. Considering the health condition of the petitioner as was reported, the following order was passed on 16/3/2026. Pursuant, thereafter, the said order was reiterated on 6/4/2026. Mr. Ansuman, you just check it.
Yes, sir.
Bhanti, you can open it. Flag A, item 16. 16 touch करो तो. Flag A देखो. Right?
For 15 or not?
16. 15 non-appears and adjourn. Date चले अपन. 15.
29.
16 देखले.
16 or not?
So scroll नो करी straight away touch flag A. Bookmark को जान तू flag A touch कर. Second page देख अपन जाके देखिए.
Flag.
Flag A रा second page देखो तो ओडिया धर्मावतार लिखा है जो.
I don't know how to.
ओडिया बड़ी बड़ी होता है.
निवेदन एक की जाए मास तारीख 26/4/2024 का इन
राजेंद्र नगर घर मुकामरे दरखास्तकारी तलाश करी ताको घरे रहउथिबा साक्षात पई मु बडे रफली पढि दोछि कारण हैंडराइटिंग मु पूरा पढि परनी पचरिबारे दरखास्तकारी को स्वामी भुवनेश्वर मुकामरे रहउथिबार प्रकाश करिबा एवं ताको फोन द्वारा जोगाजोग करिबारे ताको स्वामी दरखास्तकारी एथि पूर्वरु परलोक होइथिबार फोन द्वारा प्रकाश करिसंती. So this we guessed because she was suffering from cancer. So that has happened. So
he might have expired now.
She has passed away.
No.
Also the disposal for.
Disposal.
6/4/26. Both the orders were communicated by the as directed. The registry of this court through the honorable district judge has made efforts to serve the notice. The process server went on 26/4/26. To serve the copy of the orders to make the petitioner aware. The report has been forwarded, duly countersigned by the deputy administrator. Process establishment section. Upon देखिए लिखते हुए. Court of the Honorable District Judge Cuttack. The service report is also signed by the two witnesses. Stuff. The process server has made all the efforts to find out the house of the petitioner, contacted her husband staying at Bhubaneswar, who was informed that the petitioner has unfortunately passed away. In the meantime, stop. In view of the such development, the petition is disposed of. Yes. Yes, Mr. Mahapatra.
I may be pardoned, my lords.
No one is appearing in 21.
My lords, your lordship may just observe the order sheet, my lords.
Hello, Ashu. After recess, upon Roive na Pole.
Much. I was traveling.
Rest of the matters after recess. Once when it reached, then twice after a gap of half an hour, and again after resumption of the proceeding, the resumption of the day's proceeding after lunch recess. The matter was heard at length at some length. The matter was adjourned by the petitioner on 13/1/2026. Then on 2/2/2026, it was stopped. Well, let's stop. On 2/2/2026, the matter was heard at some length. Thereafter, on 11/3/2026, 31/3/2026, and 31/3/2026, the matter has been adjourned by the petitioner. Today, none appears for the petitioner when the matter is called, as indicated above. The petitioner is also absent on repeated call. To grant further opportunity, matter shall be listed in the week commencing 11/5/2026 for fresh admission. It shall be indicated in the cause list that the matter will be disclosed of. Copy of this order shall be forwarded to the learned counsel for the petitioner by the registrar. Yes.
That's our item 6.
None appears for the petitioner. Though the matter is called 4 times over. Once when it reached, thereafter twice after about half an hour each time. Twice after half an hour on each occasion, and again after resumption of the day's proceeding. Post lunch. Earlier on 16/4/2026, no one had appeared for the petitioner. And it was urgent granting for the opportunity with the petitioner. Rest before order joining, is there a session that some rest say.
That's our item 21.
Thank you, please, my lords. Lords, I may be pardoned that I did not reach
The non-petitioner none appears for the petitioner to second time none appears for the petitioner though the matter is
my lords, I have filed the copy.
File it in the registry.
My lords,
the petitioner none appears for the petitioner though the matter is called twice over. Once when it reached before the lunch break, and again after resumption of the proceeding after the lunch break. Item 21. Opposite part लिखिए Mr. Devidatta Mahapatra.
order dated 5/3/20.
The matter is kept pending since 20/1/2025 when it was taken up for the first time. On 21/3/2025 notices were issued. Entry order pass ହେଇଥିଲା.
The judgment was given.
Thereafter, since the requisites were not filed, other time was granted on 5/5/2025 for filing of requisites. On 22/1/2026, the matter was adjourned by the petitioner. It was mentioned by the learned counsel for the petitioner opposite party that due to stay of operation of the judgment granting maintenance, the opposite party is not getting any maintenance. Stop. The matter was heard at length on 5/3/2026. The facts and propositions of law were noted in detail. At paragraph 9, the following was observed. Paragraph 9 of the order dated 5/3/2026. Following was observed. Thereafter, 2 months have elapsed. Prior to today's listing, the matter was adjourned on 25/3/2026. 9/4/2026 by the council, of the petitioner. In view of the above, it is apparent that the petitioner is adopting a delaying tactics. The petitioner is not cooperating in taking up of the matter, even granted sufficient indulgence. For 3 months. For more than 3 months. সেটা কোন ফাইল করছেন?
সেটা ফাইল করছে যে সিপি রে বি order has been passed, my lords, resolution of marriage has happened and keeping intact this order, my lords, without granting any further alimony.
The learned counsel for the opposite party submits that in the CP
Relevant page number 7.
the following order has been passed. The CP number 190/2023 has been in CP number 190/2023, in the meanwhile has been disposed of. Granting decree of divorce. It's as sought for by the opposite party. It refers to the paragraph 8 of the order. Paragraph 8 of the judgment.
Yes.
And order dated.
Dated, my lords, 28/3, judgment dated 28/3/2026.
The said paragraphs are reproduced herein from the authenticated copy produced before this court by the learned counsel for the opposite party along with a memo. This can be taken on record,
my lords,
along with memo of date. Along with memo of date. Stop. The memo shall be taken on record. In view of the above, in considered view of this court, the petition filed by the present RPFA deserves to be dismissed, being devoid of any merit. In view of the judgment passed by the learned judge family court Sure. Granting maintenance, monthly maintenance, which was directed by earlier or judgment dated 21/2024 in CRP number 07 of 20. In an application filed by the wife in the marriage, the present opposite party. As the alimony for grant of decree of divorce. Along with the grant of decree of divorce. Further continuance of the RPFM would be not in the interest of justice. As observed in paragraph 7 of the earlier order, dated 5/3/2024, after hearing the learned counsel for the petitioner and the opposite party, by applying the principles laid in Samima Faruqi, the petitioner has not made out a case for interference by this court in revision. It has to be held that the judgment of the Lord Family Court awarding maintenance has been passed after proper appreciation of materials on record as well as the evidence adduced. There is nothing perceptible which would show that the order is a sanctuary of errors. Rather, it has to be held that the order is based on proper appreciation of evidence on record and substantial justice has been done. Stop. Further, comma. The Red Court granting decree of divorce has not granted any further maintenance and has directed the amount of rupees 10,000 per month.
6,000.
Rupees 6,000 per month is to be paid as maintenance by the opposite party in the CP. Opposite party as husband in the CP. The petitioner wife. See petitioner thile to wife. तापर ये इंसर्ट हो जजमेंट कर देते yes copy of this order shall be forwarded to the audit judge and the court Bhubaneswar to be kept on records of CP number and everything. Yes, next
Interim order may be vacated, matters.
In view of the dismissal of the RPFM, earlier interim orders stand vacated and merge with the final order.
I'm grateful, matters.
So stand vacated though. I'm grateful. Yes.
Item 30.
Posting कर दो. Anyone present for after notice matters? So Barik, your matter?
My lord.
Section number
35.
ତାହେଲେ ଆପଣ କୋଉ ଯାଏ ସିରିୟଲି କୋଉ ଯାଏ ଯାଇଥିଲେ
29.
30 ରୁ 34 ପୋଷ୍ଟିଂ କରି ଦିଅନ୍ତୁ ଯେତିକିଟା ଅଛି ତିନିଟା ତ ହେଇ ଯାଇଛି ଆଉ ଦିଟା
Lordship, on behalf of Mr. Dayani Dilenka, sir. Item number 35, Your Lordship. He asked me to pray for an adjournment A short opinion.
Post it.
Lordship.
Sir, take a short date ho.
Sir,
Chhote date se ho.
Chutti Purburus are difficult. We have to now to handle it. Tiniso matter already ହେଇଗଲାଣି. And only saving part होची जे saving grace होची जे week commencing ହେଲାରୁ distribute କରି होची. 300 matters by judicial order ता देहरे add हो करना किछटा fresh admission orders. कृष्ण को कर दियंतु गोटे date after vacation.
We commencing 13/7.
13/7 week रे आसीबो.
ई छोट
तो 13/7 तो आपण को third week of after
से
vacation.
गाड़ी फसी जेची तो नष्ट होइबाक बसलाणी सेही जो कथ
6/7 कर दियौ. हां 6/7.
Your Lordship, I am appearing for item number 34. On behalf.
Yes, next.
Your Lordship, I am appearing.
29 से 2 तक yes. आपण के चैलेंज करछन
ଆମେ ଚ୍ୟାଲେଞ୍ଜ କରିନୁ ଆମେ ପ୍ରଥମେ କରିଥିଲୁ ସେ ଆମକୁ ଦଉନାହାନ୍ତି ଗାଡ଼ିଟା ଦିଆଯାଉ ବୋଲି ତାପରେ ସେ ଆମ ଚିଠି ପାଇଲା ପରେ ଆମ ନୋଟିସ୍ ସିଏ ଆସି ଚ୍ୟାଲେଞ୍ଜ କଲେ ଏଡିଜି ଲୋନ୍ ଆଣ୍ଡ ଏଡିଜିଙ୍କର ଅର୍ଡର
ଷ୍ଟେ ହେଇଯାଇଛି ଲର୍ଡ ଆପଣ ଗାଡ଼ିଟା ପ୍ରଥମରୁ ଯେତେବେଳେ 23 ମସିହାରେ ଫାଇଲ ହେଲା ଆପଣ ରିଲିଜ ପାଇଁ ଫାଇଲ କରିନଥିଲେ
ହଁ ଫାଇଲ କରିଥିଲୁ
ସେ କଣ ହେଲା
ସେଟା ଅଛି ପେଣ୍ଡିଂ ଅଛି 31
ଆପଣ 3 ବର୍ଷ ପେଣ୍ଡିଂ ରଖିବେ ଏମିତି କଣ ହୁଏ ଆପଣ ସେଟା ପ୍ରଥମରୁ ମୁଭ କରିବାର ଥିଲା कौन कैश सिक्यूरिटी कौन दे के अपन नहीं थांते अब पेंडिंग कहीं रखिले तो बड़े आपनकर माने डिस्ट्रिक्ट कोर्ट सेटा सेट कर देले कन्फिस्केशन ऑर्डर टाको आपण सेप्टेम्बर टू 23 मसिया ही आपण कौन कैश सिक्यूरिटी कौन ले दे की ताको रिलीज करिवार थिला ना एबे आपण 3 वर्ष परे ताको गाडी रहिबो आज यू हैव सेड गाडी तो नष्ट होई सारियो This is not a correct course of action. आपण ए मैटर रे बिल्कुल आईएटा पक्की के रखियार नथिला इतले सेमाने चैलेंज कले आपण चैलेंज कले उभय अछन सो सिंस आपण व्हीकल रिलीज पे रिट पिटिशन कर देना देन ऑन करछ यू जस्ट इन्फॉर्म मिस्टर लेंका कैश सिक्योरिटी देख से गाडटा नेबे गाड तो गलानी गाडी अब कुछ नथियो केबे कन्फिस्केशन केबे ऑर्डर हेतला सीजर केबे हेतला 5 वर्ष हेगलानी तो कौन तेज कौन करछन ठीक अछि मिस्टर चाम 36 आफ्टर वेकेशन
I want to picture.
यस आरो साइड नाहंती
Well,
टेक ए डेट
आगे लास्ट.
Your Lordship, I am appearing for item number 34.
13/7 yes
Lordship, I am appearing for item number 34.
anyone please 7 to 40 तो बड़ा डेट क्वेश्चन यस 34
Yes, Your Lordship. I am appearing for opposite party number 3.
थर्टी फोर 13/7 अर्जन ହେଇଛି ସକାଳେ ମେନସନ କରି अर्जन କରିଛନ୍ତି
I will oblige you.
ଆପଣଙ୍କର
38 year lots.
take a date
Your Lordship, in this case, both the parties are agreed to mutually settle this matter. So we are planning for this matter to be sent.
ସେ ଆର ସାଇଡ୍ ଆସନ୍ତୁ ଆପଣ ଯେତେବେଳେ ସପୋଜ ଦ ବେଷ୍ଟ ୱେ ଇଜ ଦ୍ୟାଟ୍ ଆପଣ ଯଦି ରାଜି କରେଇ ପାରୁଛନ୍ତି ନଥିଙ୍ଗ ଲାଇକ୍ ଇଟ୍ ଗୋଟେ ଆଫିଡେଭିଟ୍ କରନ୍ତୁ ଏବଂ ମେନସନ କରନ୍ତୁ
Yes.
ହେଲା ଜଏଣ୍ଟ ଆଫିଡେଭିଟ୍ ଦେଇକି ଗୋଟେ ମେନସନ କରନ୍ତୁ ଦେନ୍ ୟୁ ସି ଦ ରେସ୍ପନ୍ସ ଅଫ ଦ କୋର୍ଟ
Yes, Your Lordship.
ୟେସ୍
we commencing 13/7.
ୟେସ୍ ମ୍ୟାଡାମ ଆପଣଙ୍କ ମ୍ୟାଟର 33 ଆପଣଙ୍କର ଆଫ୍ଟର ନୋଟିସ୍ ମ୍ୟାଟର ଗୁଡାକ ଆଫ୍ଟର ଇଏ
That matter can be disposed of my land.
ଆମର କଣ କି your lordship mediation ରେ ହେଇଯାଇଛି joint affidavit ବି compromise ହେଇକି file ହେଇଯାଇଛି
ଠିକ ଅଛି one second just take your seat I'll take it up pass over ଆପଣ କଣ କହୁଥିଲେ ସେଟା ଆପଣ ଗୋଟେ just like madam is mentioning ହେଲା ପରେ mention କରନ୍ତୁ and it will be immediately done ହେଲା
Then maybe I'm
ଆପଣ liberty to mention is always there even if it is posted ଆପଣ ଗୋଟେ memo ଯଦି ଲେଖିକି ଦେବେ it will be listed yes 33 call କରନ୍ତୁ
33.
Miss Mrs. Aditi Hota for the petitioner Mr. Amit Kumar Nath for the opposite party
yes sir matter has been settled in mediation joint affidavit has also filed your lordship
Yes.
18 lakhs 50,000. We have already
Petitioner,
paid
husband
10
and,
lakhs.
the opposite party wife have agreed for settling the matter between them and closure of and bring an end to all the litigations. Yes. The mediation report dated 12/1/26 is placed on record, which bears signature of the learned mediator, signature of both the petitioner and the opposite party, and the learned counsel respectively appearing for them. The joint affidavit filed before the mediator is also available on record. Paragraph 5 of the said affidavit is reproduced herein. 5, 6, and 7. In view of the above, the petition is disposed of.
I may be pardoned, Your Lordship. Our small prayer is before Your Lordship is out of 8 lakhs 50,000, we have already paid 10 lakhs. And so far as rest amount 8 lakhs 50,000 is concerned, SETA that should be kept in the name of the minor son. Of the- But bank is saying that unless until the order is not there, I can say withdraw करके भी नहीं परिवे. So
only 5 years, my lord.
5 years.
Here the page 2 of the joint affidavit.
सेटा आपनकर mediation agreement अछि.
Yes.
मु तो कहबले Master Prasad Kumar Das by the first party 3 months भितरे.
Yes.
Bank बना केमती करिवे? Part of the order.
Your lordship will reflect the order sheet so that
the order sheet रे तो para 5 कोट हैला. ଆପଣଙ୍କର ଟଙ୍କାଟା 8,50,000 ରହିବ ପ୍ରସାଦ କୁମାର ଦାସଙ୍କ ନାଁରେ ତ ଲେଖା ହେଇଛି. The Lord Counsel for the petitioner as well as the opposite party submit that for each of each of doing business. এটা কোন? এটা তো কিছু নিরর্থক কামটা. For convenience of both the parties. না এমতি লেখন্তু. Submitted that the parties have already agreed that as reflected in paragraph 5 into bracket Roman 2, Roman capital 2. So that rupees 8,50,000 into bracket rupees 8,50,000 shall be kept in the name of Master Prasad Kumar Das by the petitioner father, by the first party father within a period of 3 months. In 3 installments.
Mother, sorry, mother. Mother.
Father.
Mother na father?
Mother. I am agreeing for father.
Mother लिखता है ना first party second party कर देने. अच्छा, the mother shall deposit over 3 months.
Father shall deposit.
In 3 installments, 3 lakhs. केबे सुधा 3 लाख देबे?
8,05,000, my lord. 10 lakhs already, we have 10 lakhs already received, my lord.
कौन सुनु नांते आपण से फादर मदन कोळे आले. आपण जो अनुनांती की ब्रीफ टा गुडी.
हां देखछि.
हां 3 लाख टका आपण लिख पढिले. बुझि पछुंती.
3 lakh टका already we have received, my lord. His, my lord.
अरे we have received no 3 लाख टका जो आपण लिखि चंती डिपॉजिट करिवे 3 लाख गोटे 2.5 लाख गोटे और 3 लाख गोटे. सेटा फिक्स्ड डिपॉजिट केबे करिवे?
ना मुनु से डिपॉजिट करिवे, my lord.
अरे जी भी हो.
ना that also, sorry, my lord.
You are ready. आमे ready है कि अच्छो करिवो.
एकाथरे करिवे ना नहीं?
आमे एकाथरे के करिवो किंतु 18 years हेले मेजॉरिटी अटेंड करले से सेटा को सीए ही ड्रॉ करि परिवो.
सेटा लिखियो हो. सेटा ताजे नाही ना सेटा को आपण सेतोळे देखा जिवो. तो देखा जिवो कोन लिखियो. आपण मदर को पे
फादर petition फादर
ये तल डिपॉजिट करो फाइनल डिसाइड करो
नहीं सुसे डिपॉजिट करी
फादर करिवे
फादर
at the first, 3 lakhs as first installment, 2,50,000 second, and 3 lakhs as third installment. Upon such deposit being made, minor guardian ki hebe.
Mother.
Mother.
The fixed deposit shall be made in a high interest bearing account with auto renewal clause in name of the minor. The mother being the guardian. The amount shall be kept as such. In any nationalized bank, as would be convenient to the father and mother both. For dispersal of the amount for any benefit of the child, as he would attain majority, appropriate application shall be filed before the learned judge, family court, the court here.
Hon'Ble.
Family court on
Hon'Ble. This have realized that the 18 वर्ष में bike किनी बुलियो से.
My lord, every 3 months he also, if he interest bearing.
से कोन दहिबरा खाइबो ना.
3 years
जो जेतळे आपण वर्तमान 18 लाख टाका ताकू देले आपण केते 8 लाख.
8,50,000.
5 वर्ष रे ताकू वर्तमान 5 वर्ष ताकू 10 वर्ष होला बेलको हेजियो केते बेले हेजियो 17.
एबे my lord, sorry my lord, 3 months ता interest bearing account गुडो खोला हो जोडे पैसा दिया हमन से पढियो केमती.
अरे कोटी अछि आपण गोटे प्रॉब्लम हो आपण किछि पढु नांती गोटे मत नै कहउछन. अरे कोटा पढुचंदी गोटे रेफर करंतु टिके सो दैट मु भी जानि परिबी.
ना ना सी that is not.
No,
से भाबुचंदी तो हम भाबंतु.
My lord, there is also your lordship agreement to that first party shall pay a sum of 8 lakh.
नहीं सेटा नहीं आपण जो इंटरेस्ट पाइबे पाठ पढिबे सेटा कोटी अछि देख. अंतर से भाबु थाम सेंती भाबिबे आपण.
In favor of minus shape of
सेमिति करी केस खराब करंतु गोटे रेस्पेक्ट दियंतु गोटे मेडिएशन रिपोर्ट को दियो आपनकर सबुदिन किछि किछि नुवा नुवा आईडिया हो मोठो आपन तो अधिक आईडिया हो लाभ कोन हो. You must respect.
Yes.
Read Jalursi.
My lord, there is national
Supreme Court has commented upon this approach that we are imposing our views. आपण को हठात कहले जे पाठ केमती पढिबो पाठ आज्ञा फ्री.
English medium.
इंग्लिश मीडियम रे पढिथिबे मु जो पढिछि पूरा फ्री.
I am also reading in a village school. That also free and fooding also some.
माने बेस्ट कॉलेज बेस्ट यूनिवर्सिटी फ्री ऑलमोस्ट.
Yes, I also.
100 टका पिला आपनकर सेंट्रल यूनिवर्सिटी रे पैसा दिल्ली रे. तो सेटा बड़ कथा नो आपनकर थरे गोटे एग्रीमेंट हला से तांकर जेतले अधिक तांकर एक्चुअली 18 वर्ष बेलको बेसी पैसा दरकार पड़ी पारे. तू जदि बाइक चढ़ी बुलिले तो तुम कहि जेतियो बर्तन 8.5 हैला 8.5 17 17 जो 34.
My lord, there is also in shape of fixed deposit in any nationalized bank bearing interest thereon for the period of 5 years and first party also interest amount that's all to the son, my lord.
ऐड करंतु नी. I have to reject your prayer. आपण जदि खुशी लागुची गोडा लेखिबी एवं लेखिबी जे सेटा यू आर गोइंग बियॉन्ड द ये आपनकर इमेजिनेशन टा भीतर भर्ती करंतु नी मिस्टर नाथ. बी रेस्पोंसिबल एज अ लॉयर.
Yes, ma'am.
Don't be irresponsible. I have to record that you are irresponsible.
Only fixed deposit, your lordship.
Only fixed deposit मु कोन कली. आपण मते बाध्य करछन देखिया पे कोचन एटा हेई पारुनी.
ना
मु तो कोर्ट 27
ठीक है.
I have agreed. And very well you should be happy with that.
Yes.
आपण केते टका नेछन. आपण वाइफ ना आपण हस्बैंड को पे.
Wife.
आपण केते टका नेछन.
10 लाख.
Wife needs 10 lakhs.
10 लाख जो इंटरेस्ट भरे तो पिला पढांतु.
That's
नहीं सेटा आपण पढेबे. आपण टकाटा निजे खर्च करी. Anyway,
maintenance.
तो सेटा let us
It recorded.
से मेमोडा कोन.
We have already paid that 6 lakhs.
ताको दस्तखत करेगी. या दोचोदी रिसीव कर
करे देछि रिसीव करे देछि.
अच्छा.
तांका क्लाइंट करे देछि.
हैला. कोन लिखले लास्ट. नहीं सेंटेंस पूरा पढ़ो. Nationalized bank as agreed between the in high interest bearing account with auto renewal clause. Father and mother-in-law as would convenient to the mother and child.
Discussion of the amount of any benefit to the child.
Right, for dispersal of the amount kept in the bank as fixed deposit. For any legal necessity or other necessity, for any necessity of the child, the mother shall approach the learned judge family court, giving the details of such necessity. And the learned judge family court shall pass appropriate learned judge family court Hon'Ble, and the learned judge family court Hon'Ble shall pass appropriate order on the application as and when it would be filed. Memo of date is filed by the learned counsel for the petitioner, enclosing photocopy of bank draft, so and so likhila, and a signature contained in a page with a certificate signed over a revenue stamp. The memo along with the enclosure shall be kept on record. Copy of the memo has been served on the learned counsel for the
Another
opposite party.
Another we also clause is also there that all the criminal cases will be withdrawn by the opposite party number.
The criminal cases, the cases filed by parties between against each other shall be dropped forthwith. केस लिस्ट करी दियो साइड पे पूरा कागज दियो जो केस ड्रॉप होबो जो केस नंबर as per the following list.
Also मालो para 3 also
गोटे जगह सर आपण इंटरप्ट करंतो केस लिस्ट करो the cases that those may have been filed against each other by the parties shall be dropped forthwith upon production of the certified copy of this order before the courts in session of the matter. The court shall not insist for any further affidavit from the parties. The list furnished signed by both the learned counsel for the parties, indicating the number of the case, the court in which it is pending, is taken on record. Copy of this order shall be forwarded to by the registry of this court to the said courts. So, memo I can do jaldi kar diyo.
Sorry मतलब para 3 टा confuse करा है para 3 Roman 3
सब है क्या पूरा साइज रोमान से डिलीट करिवे डिलीट ही करियो
ना एटा include करा है नहीं तो father first party the grandfather was registered land in the name of grandson
आपण बुझ पर नांती para 5 रो 1 2 3 para 5 6 7 पूराटा रिप्रोड्यूस हेच
ठीक
इनको स्लो हे चंदे आपण
पदना रेजिस्ट्रेशन नहीं
ଆପଣଙ୍କର ରିପ୍ରୋଡ୍ୟୁସ ହେଇଛି ପୁରା 5 6 7 କିନ୍ତୁ ପୁରା ଟାଇମ କେସ୍ ଲିଷ୍ଟ ଦିଅନ୍ତୁ କୋଉ କେସ୍ କୋଉଠି ଅଛି this court puts on records its appreciation of the efforts of the learned counsel for the parties, Mr. Sota and Mr. Nath, for making it possible for the parties to arrive at amicable settlement acceptable to both. ନା ସେ ଗୋଟେ ମେମୋରେ ସେ କପିଟା ଆପଣ ଆଉ ଗୋଟେ ମେମୋ ଦେବେ ଦିଟା ଯାକ ଦେବେ ତାଙ୍କୁ ରିସିଭ୍ କରିବେ yes anything else Mr. Nath? Yes
the order should comply within
ଏଇଟା କାହିଁ କ୍ୱେଶ୍ଚନ ଚାଲିଛି ଟିକେ ବ୍ୟସ୍ତ ହଉଛନ୍ତି ଆପଣ ଯେମିତି ହଉଛନ୍ତି ବଡ आप बनाया खेल बिगाड़ दोगे आप जैसे कर रहे हो कौन भावुଛନ୍ତି कौन कहउଛନ୍ତି This item 40 Mr. Das just call serially call करो आप को जाए कॉल 33 33 रुपये कॉल करो 34 adjourn नहीं वाला 35 35 कॉल करो यस 35 टा गला
35
अच्छा 36
36
37 कॉल
33
Something I am appealing to respond.
आफ्टर वेकेशन डेट नहीं है बस
we counsel pair sir
कॉल करो
39
35 टा कौन adjourn नहीं
38.
वही है ना हम मुझे जानी
38, I am for the respondent, my lord. If the matter may kindly be referred to mediation, there is a scope of compromise, my lord.
नहीं आपण एग्री करी कि आसंतु
Agree,
एफिडेविट दियंतु जस्ट नाउ देखिले एटे मेंटेनेंस ना कोन पाई फाइल होची
maintenance.
मेंटेनेंस पे कोन आपण निजे उग से देबे आपण देबे ना कोन एतर कंप्रोमाइज कोन हो आपण जदी सेटल करिया चाहउछती फाइल दैट एफिडेविट हियर otherwise the mediation system is getting overburdened. You have a better chance to mediate and settle it here. It's fortune. Always there's liberty to mention. I was informing your learned colleague. Just prepare affidavit and file it here. There should be some basis.
Yes.
So that it will be easier for you to tell the parties also.
Yes.
It's fortune.
Yes.
Yes.
Oh, blessed.
39
Yeah, please, your lordship.
This is for after notice hearing, madam.
Yes, ma'am.
So after vacation.
No course action ହେଇଛି he is not getting single file, madam.
କହୁନାହାନ୍ତି
ନା କିଛି ନାହିଁ, nothing. No course action, only no course
The
action.
question is to be decided whether she is entitled to get the maintenance or not. For which the Honorable High Court has been pleased to give direction not to take any coercive action against the petitioner, my lord. The husband has filed CP before the family court, my lord. The divorce case is pending. So, my lord, why?
Divorce case re maintenance
Resolution of marriage. He has filed petition for. He has filed petition for resolution of marriage. Marriage is there. Marriage is there.
Divorce case जदी फाइल कले maintenance फाइल बोले केमती कहउछन
No, my lord, why I am saying that both the parties are.
नहीं आपण don't give a speech sir madam. Go to the pleadings, evidence and case law. That's it.
Both the parties are Mohammedan, my lord. They are governed under Mohammedan law.
Don't give a commentary. Straight away come to the pleadings, evidence and case law.
Yes, ma'am. That's
Straight away. Don't. I can by my knowledge also I know that both are Mohammedans.
Both are Mohammedan, my lord. That suppressing the fact that prior
You raise any decision on this?
the registration of marriage, she had married one Mikhail Khan.
Whatever, madam.
Without giving.
That is beside the issue, madam.
Yes, ma'am.
If you read the law, because you have not read, that is the problem you are saying, because she was married to Mikhail Khan, so I am not entitled. Have you taken that plea before the trial court? So that.
Yes, my lord.
So that. Show your evidence.
Yes.
देखिछन देखिछन देखांत एविडेंस रिटन स्टेटमेंट आगे देखांत This was the reason, madam, I was telling that it should come after vacation because it creates lot of wastage of time. You must understand.
Yes, my lord.
If you are not prepared, tell me frankly, because I'll go at my speed. I am not here to listen to speeches. Straight away, come to your pleading written statement where you have stated this and what is your evidence.
My lord, evidence, my lord. I have stated.
You have a written statement ko jantu. You are dealing with a revision. Who page, who paragraph? Description कोना पड़ देखि ना मते का लागुनी हेई परियोनी से आफ्टर वेकेशन आसु
जे मेंटेनेंस तो किछि दियो तो 10000
गोटे कोऑर्डिनेट बेंच जेते बेले ऑर्डर करछिन व्हाट आई कैन डू आई अंडरस्टैंड आई गॉट योर पॉइंट सर एंड व्हाटएवर मैडम इज सेइंग दैट इज कंप्लीटली नॉट सस्टेनेबल दैट आई अंडरस्टैंड
रेडी ना
You read Samima Faruqi exactly on between two Muslim persons by Honorable Justice Deepak Misra. Then you will realize that what you are arguing is completely bereft of any merits. 125 is not regarding the proof of who is married or not married.
Madam, may I pray one thing, madam? If possible, before vacation, any date? If possible,
sir, just, sir, when you start struggling with your single case with pleadings, then it is a Herculean task for the court. The practice adopted is that to go just not to refer to pleading, not to refer to any of the.
Paragraph 10 of my WS, my lord, I have stated. Paragraph 10 of my WS. Page 36, running page 36.
TCR trial court record देखुची running page more 9.
Para 10, my lord. At the time of marriage, the petitioner has not disclosed that she is married lady and having a child due to undue influence and coercion applying fraud. Under such circumstances, by force, threat and suppressing material facts, with regard to previous marriage, the petitioner able to prepare a certificate before the marriage officer. My lord.
नहीं अपन speech दियो तापरे ताकू क्रॉस एग्जामिन कोठी कले पचारले कोठी ताकू
तार क्रॉस एग्जामिनेशन से मानिची. But she has not disclosed in her petition.
That is whether she has disclosed or not, that is not important. My lord,
you kindly see the cross examination of the opposite party, my lord. Page. Further cross.
Deposition
she has admitted. I know Mikhail Khan, whom I married earlier. I led my conjugal life with him. My marriage with Mikhail Khan was solemnized in the year 2016, but I cannot remember the exact date. Mikhail Khan is alive. The marriage in between me and Mikhail Khan was dissolved according to Mohammedan customs. I gave divorce.
That's it.
She has said, but she
you have lost the case, madam.
There was no document.
Once he says that then
only she said, my lord.
That is enough.
He had not proved that marriage has been
dissolved. Prove. You have to say that the marriage sustains. It is your case in written statement. Your case is that she still marries to Mikhail Khan, because you have unwittingly you have spoiled your case. You should not have raised that point.
This is not my lord.
You check the next question. ଆପଣ କୋଉଠି ପଚାରିଲେ ଯେ that you are still married to Mikhail Khan, that I want to see. ଯେତେବେଳେ ଅଧିକା question ପଚରା ହୁଏ cross examination ରେ ये result ହୁଏ. You have read this proposition that since she is married to Mikhail Khan, I am not entitled to pay anything. You have asked her and she said that yes, I was married and then it has been dissolved. It was your duty your duty to
she
prove.
Has not proved, my lord. She has
100% proof.
I have not given a notice to
Madam, she is not to prove your case. She is the petitioner. You have to prove your case to sustain the challenge that yes, she is married to Mikhail Khan. Second marriage is not prohibited in Muslim law. Read Mullah or Faizi, it is not prohibited. And it is easier there also. She can seek khula.
Yes.
You must understand that.
That is not.
So this is not a Hindu Marriage Act that once it has to be judicial pronouncement, section 9 or 13, not there. That is enough.
She is an advocate, my lord, practicing advocate in Bhadrak, my lord. She is capable of maintaining herself, my lord. And the husband.
Read, madam. Whether she is capable, you have to read and you have to read the judgment.
Yes, ma'am.
Even if she is a millionaire, she is entitled for. You can claim that's a different thing. But this argument that she is capable of maintaining herself is not sustainable in 125. It has been dealt with.
And one thing, my lord, she wants to stay with the petitioner, my lord. She wants, in spite of all these things, she has stated in her cross-examination.
Again, maintenance argue करछन. Maintenance 125 argue करछन. She wants to stay. She is married to Mikhail Khan. She is divorced from Mikhail Khan. What is this? Do you understand that in case of any mutual cohabitation, 125 is maintainable? Much less a marriage is to be proved.
The is pending. Let the matter be referred to mediation.
No, maintenance से मुझे mediation करेगा. वो आगे maintenance से mediation करेंगे क्या ना? मत्ते तो मुझे तो पैसा देवे नहीं ना. पैसा किए दबो ना दो मुझे mediation कौन करी?
They may reunion.
Say reunion पैसा दियो तो reunion कौन तो? चित्र कौन अच्छी की? Payment of maintenance will be not a.
Kindly be hard on merit, my lord.
No case. Hard hearing concluded, judgment.
And after vacation, my
lord. No, not now. I told you. If I'm opening the brief, I'll conclude it. If I'm opening, I'll conclude it. I'll not leave it like that. Because this is a gross wastage of time on my part, madam. If it is a serious hearing, it has to be serious in true sense. I have looked at the brief enough. Where you have proved that, you have to show me that in the written statement, you have proved that she is married and she continues to be married to Mikhail Khan. Whether she is married 3 times or 4 times earlier is not a relevant consideration as far as 125 is concerned. If any case law that earlier married lady is not liable to be maintained, straight away cite that. I asked you. Nothing. Judgment is up. Mrs. Prabhasi Naik for the petitioner. Mr. Pradeep Kumar Das for the opposite party. The learned counsel for the parties were heard. The pleadings as available in the trial court records, the evidence entered by the parties as available have been placed by the learned counsel for the petitioner. The learned counsel for the opposite party only made his has made only his brief response, submitting that the judgment passed by the learned judge family court is just and proper and not liable to be interfered with. Yes. କେତେ ଟଙ୍କା ଦେଇଛନ୍ତି?
10,000 my lord.
10,000.
10,000.
ସେଇଟା ଯଦି ସେ ଆପଣ ରାଜି ହେବେ ତାହେଲେ କମେଇବେ ନହେଲେ ନାହିଁ।
She is not. He is not.
ସେଇଟା ଆପଣ ଯଦି କହିବେ କେତେ ଜାଗାରେ ରାଜି କିଛି କମେଇବେ?
ମୁଁ ଆଜ୍ଞା ଏଜୁଅ ଲଟ୍ସ।
ନା ଆଜିଓ ଲଟ୍ସ ମୁଁ ଆଜ୍ଞା ପଇସା ଆପଣଙ୍କର କେତେ ଦରକାର ସେ କେତେ ଦେଇପାରିବେ?
5 ବର୍ଷ ପ୍ରାକ୍ଟିସ।
କେତେ ଟଙ୍କାରେ ହେଲେ ଯଦି କିଛି କମେଇବେ ମ୍ୟାଡାମ ଖୁସି ହେଇକି ଯିବେ। ସେଇଟା ଆଡଭୋକେଟଙ୍କ ପାଇଁ।
ସେ is unemployed my lord. He is unemployed now.
ଆଜ୍ଞା ବସ୍ ଚାଲିଛି ଟ୍ରେଡର୍ସ ରେ ମାଲିକ that is the finding of the law.
ଠିକ ଅଛି।
No, income of the petitioner has not been determined by the.
What I have achieved, that I am experimenting. What I have achieved, that at times the wife is ready to give up some money. But that will record both your consent. But she যদি କହୁଛନ୍ତି you are capable enough, ଆଜିକାଲି ଯୁଗରେ ଆଜ୍ଞା 10,000 ଟଙ୍କା କିଛି ନୁହେଁ।
My lord, without determining the income of the petitioner, my lord, the Royal Trial Court has said that as he belongs to well-to-do family, he is supposed to pay 10,000. Where from High Court, my lord?
ଆଜ୍ଞା କୋଉ ଫ୍ୟାମିଲି well-to-do 10,000 ଟଙ୍କା ଦେଇପାରିବେନି? 10 ଲକ୍ଷ ଟଙ୍କା ହେଇଥିଲେ, if you look at the figures Supreme Court is dealing, those are in lakhs, 20 lakhs, 25 lakhs. It is a 10 ଲକ୍ଷ ଟଙ୍କା, 10,000 ଟଙ୍କା।
10,000 ଟଙ୍କା she is not able to pay my lord. ତେବେ ତାର ସବୁ ଯାକ ଭାଙ୍ଗି ଦେଇଛନ୍ତି ଆଜ୍ଞା, ଡେଷ୍ଟ୍ରୟ କରିଦେଇଛନ୍ତି। ତାର ଯୋଉ କର୍ପୋରେସନ ଚାଲିଥିଲା ଟାଇଲ ଫ୍ୟାକ୍ଟ୍ରି, ତା ନାଁରେ କ୍ରିମିନାଲ କେସ୍ ଆଜ୍ଞା ସେ ଜେଲକୁ ପଳେଇଲା।
Same problem. Again you have started a speech. ଆପଣ ସେଟା ଟ୍ରାଏଲ କୋର୍ଟରେ ଯୋଉ ଭଙ୍ଗା ହେଲା ତାର ଏଭିଡେନ୍ସ ଦେଇଥାନ୍ତେ।
ଏଭିଡେନ୍ସ ଅଛି ଆଜ୍ଞା।
ସେଟା ଦେଖିବା ମୁଁ ଦେଖିବି ଥିବ ତାହେଲେ again I post it for to be mentioned. ତାଙ୍କର ଇନକମ୍ ନାହିଁ ଯଦି ଟ୍ରାଏଲ କୋର୍ଟ ଆରାଇଭ୍ କରିଛନ୍ତି
ଇନକମ୍ ନାହିଁ ଜିଏସଟି।
ଆପଣ ଜଜମେଣ୍ଟଟା ଟିକେ ପଢିଲେ, ଜଜମେଣ୍ଟରେ ଯୋଉଠି ଇନକମ୍ ଡିଲ୍ କରିଛନ୍ତି। Page 16, paragraph 7.
Page 16.
Petitioners claims that
Paragraph 7 सीधे जाते हैं. Let us save time actually, because
last paragraph my lord kindly see 15.
15 ने para 7 देखो. On the other hand,
that is the petitioner has filed, but the OP filed documents before the court for referral, which shows that the income of
ଆପଣ ଆଜ୍ଞା ଯୋଉଠି ଡିଲ୍ କରିଛନ୍ତି ଜଜମେଣ୍ଟ ସେଠି ଜଜମେଣ୍ଟ କୁ ଯାଆନ୍ତୁ। ପାରା 7 ରେ ଯାଆନ୍ତୁ। ପାରା ସେଟା ଆପଣ ଦେଖିଛନ୍ତି କଣ କଣ ଫ୍ୟାକ୍ଚୁଆଲ ପଳେଇଲେ ଆପଣ। पेज इंटरनल पेज 7 रनिंग पेज 16
counsel for be vehemently opposed the
ये पाउना
para 7 mile
for contra
contemplate करछि
on the other hand is an able bodied man
be vehemently opposed
तो कोठी पढुछन मते को मु सेठी पाइयो सेटा मु पाउनी ना आपण जोडा पढुछन कोन कोन
second line of this page on the other hand
On the other hand, the OP is a able-bodied man and he is highly qualified. He has completed BTech in mechanical engineering in 2014. The OP also owns 2 numbers of 4-wheeler vehicles and earning handsome amount of money from business. He is also proprietor of Mesa Honors Corporation, Champua, Keonjhar. So he cannot absolve his liability from maintaining the petitioner who has no source of income at all. With this submission, Law and Counsel prayed. So it is their submission. But the finding of the court is, my lord, your lordship kindly come to para.
ଆପଣ କୋଉଠି ଡିନାଇ କରିଛନ୍ତି ଆପଣଙ୍କର ଷ୍ଟେଟମେଣ୍ଟ କୋଉଠି ଡିଲ୍ ହେଇଛି ଆପଣଙ୍କର ଆର୍ଗୁମେଣ୍ଟ ହେଲା ଯେ ଆପଣଙ୍କର କିଛି ନାହିଁ ୟୁ ଆର୍ ଏ ପପର ସେଟା କୋଉଠି ଦେଇଛନ୍ତି
para ମୋର ଯୋଉ ଏଇଠି ଆଭରମେଣ୍ଟ ଅଛି ସେଇ para 7 ଅଛି. For contrary, Law and Counsel for OP vehemently opposed the above submission. It was submitted that the whole case of the petitioner falls flat for a sole reason. The petitioner is not legal married wife of OP. Both the parties are governed under Mohammedan law. In fact, there was no marriage and conjugal relation between the parties. In fact, the petitioner is highly educated and she got married to Mulkhan Khan. Out of their wedlock, a male child was born who is now aged about 6 years. There was no divorce between the petitioner and the
ଅଛି ସେଟା ଅଛି
it court held କରିଛନ୍ତି that she has filed the GST from 2022
ସେଇଟା ଆପଣଙ୍କର ଷ୍ଟାଣ୍ଡ ସେଇଟା
25 which shows his zero income.
ଆପଣଙ୍କର ଜିରୋ ଇନକମ୍ ପାଇଁ ସେ କୋର୍ଟ ଆପଣ ଏବଲ୍ ବଡିଡ୍ ମ୍ୟାନ୍ ଆପଣ ଇଏ ଡେଲି ୱେଜ୍ ରେ କାମ କରିବେ
ନାଇଁ ଲାଷ୍ଟ
you have to read Samima Faruqi and then read Rajnesh versus Neha. Able bodied man after selling his business what he will do କାମ କରିବେ ଡେଲି ୱେଜେସ୍ ରେ ଦେବେ ପଇସା ଆପଣ ସେଇ ଦୃଷ୍ଟିରୁ 10,000 ଠିକ ଅଛି.
It last କହିଛନ୍ତି it can clearly be presumed that OP belong to well-to-do family and is having good business establishment but no conclusive opinion regarding the income of the OP can be drawn.
ଆଜ୍ଞା ନହେଲେ ଆପଣଙ୍କର ଯୋଉ ଆପଣଙ୍କର ବସ୍ ଆଉ ଯଦି ଆପଣଙ୍କର ଅନୁ ଟ୍ରେଡିଂ ଥାନ୍ତା ସେ ଆପଣଙ୍କୁ 50,000 ଦେଇଥାନ୍ତେ ବୁଝିପାରୁଛନ୍ତି 10,000 ଦବାର କାରଣ ହଉଛି ଯେ ଆପଣ ଯେହେତୁ ଆପଣଙ୍କର ବସ୍ ନାହିଁ ଅନୁ ଟ୍ରେଡିଂ ନାହିଁ
ବସ୍ ନାହିଁ ଚାଲିନି ବସ୍ ଟା ଫାଦରଙ୍କ ନାଁରେ
ଆଜ୍ଞା ମୁଁ କହୁଛି ବସ୍ ନାହିଁ ଆପଣ କହୁଛନ୍ତି ବସ୍ ନାହିଁ ଚାଲିନି let us not repeat each other statement
ନାଇଁ ସେଟା
kindly listen what is being told to you
sir court held କରିଛନ୍ତି
ଆପଣ କୋର୍ଟ ଯଦି କହିଥାନ୍ତେ ଯେ ହୋଲ୍ଡ କରିଥାନ୍ତେ ଯେ ଆପଣଙ୍କର ବସ୍ ଅଛି ଦୋକାନ ଅଛି ତାହେଲେ 50,000 କରିଥାନ୍ତେ 10,000 କରିବାର କାରଣ ହଉଛି ସେଇଟା କୋର୍ଟ has justified that
बस भी स्टॉप ହେଇଯାଇଛି ଆଜ୍ଞା ଚାଲୁନି ମୋର ବସ୍ ବିଜନେସ ନୁହେଁ ମାଇ ଫାଦର ଇଜ ଡୁଇଂ ବସ୍ ବିଜନେସ
whatever ଆପଣ କିଛି କରନ୍ତୁନି ଲାଗିବେ କାମ କରିକି ପଇସା ଦେବେ ଆଉ you read Rajnesh versus Neha and Samima
she is not capable ମାନେ
ସେଟା ଅଛି ଆଜ୍ଞା incapability has been dealt with I will deal with that
that is well
ଲେଖି ଦିଅନ୍ତୁ it is submitted by the Law and Counsel for the petitioner that the petitioner is not has stopped doing any business is incapable of earning ଏତିକି ଲେଖି ଦେଇଥିବେ everything has been clearly dealt with court re incapable par paisa nahi कहले court कोन करिवो सेटा already fixed सेटी supreme court review file करे
if it is held that I will be liable to pay my lord
not liable आपनकर तांकर first marriage cannot be a ground for stopping payment बुझ परछंती you have
my lord the only
problem ei problem केते बेले हुए जेते बेले वकील निजर बुद्धि अप्लाई करंतिनी क्लायंट कथारे चलंती ए प्लीटा सेठी कोन नबार थिला married to Mikhail Khan ଆପଣ ଯଦି ଯଦି ଆପଣ ମ୍ୟାଡାମ ଯଦି ଆପଣ ପ୍ଲି ନଉନାହାନ୍ତି during subsistence of the first marriage she has married for the second time okay that's fine you are not taking that plea you must understand what you are arguing in a 125 petition this is what is called common sense argument untenable in law আমি লোকରେ ବହୁତ ଖରାପ ଲୋକଟା ଆପଣ ଯେତେବେଳେ କହିବେ କୋର୍ଟରେ କଣ କହିବେ ବହୁତ ଖରାପ ଲୋକଟା କୋର୍ଟରେ କହିବେ ଯେ ସେ ଏଇ କାରଣରୁ ଖରାପ ଆପଣ ସ୍ପେସିଫିକ ପ୍ଲି ନେଇଥାନ୍ତେ ଆପଣଙ୍କର main fulcrum of argument is that because she was married for the first time she is not entitled
well as per the Supreme Court guideline she is supposed to file an affidavit for disclosure of his assets and liability my lord
ତା ପର ଲାଇନ୍ ଟା ପଢି ନା ଆପଣ ସେ ଲାଇନ୍ ଆପଣ ପଢିକି ଯୋଉ ଆର୍ଗ୍ୟୁ କରୁଛନ୍ତି Supreme Court has not said that when affidavit is not filed, maintenance cannot be granted.
No, I don't think so. But she is an advocate. She is supposed to file. She has suppressed the things. She might have received meher from her first husband. She is getting maintenance.
So again, you are faltering there. You should have taken that stand that she has received meher. Receiving meher is a necessity for a sustainable khula. You must understand that. what you are arguing contrary to law.
No, she is supposed to get the mayor when she will
After getting khulla, after iddat period, she is ready to marry. You must understand that. So you have spoiled your case by not applying judicial. I mean, not madam, you are not conducting counsel, I understand. But I have to say you, when you do not read law, apply common sense logic and spoil the case. These are not tenable grounds. To certain extent, Muslim personal law is liberal. After the iddat period, it is not like declaration of a subsistence of a marriage can only be terminated by a decree of court after 1956. But in Muslim law, simply one can seek khulla.
She is entitled to get the maintenance till iddat period, and so after the coming of this act,
Sahoo Begum settle
divorce woman.
Upon 125 upon Kohili, upon Podivana Tila Justice Mr. Judgment. Samima, I am relying on every Hindu Marriage Act case on Samima Faruqi. Samima Faruqi is not case of a Hindu, it is between 125, Samima Faruqi and Sahid Khan. They are Sahid Khan to voluntary retirement on the same ground, not to pay any maintenance. And way back then it was 4,000. Now if you compare 4,000 will come 15,000.
She will get the my lord.
This anxiety, you see, you must understand. If the law entitles her to pay, you are paying. You are not doing any favor. You may like it or may not like it.
Well, that at the same time, the capability of the
Capability, yes, capability. Daily, you are not listening then. At least 10 times I have said that you have to work, earn for yourself and feed your family. This point has been settled by the court, Supreme Court. Incapacity to earn is to be that it has to be proved on valid grounds.
The capacity should be.
ଆପଣ ମୂଲ ଲାଗିକି କାମ କରିବେ ମୂଲ ଲାଗିବେ
10,000 ଟଙ୍କା ଦେଇପାରିବି ମୂଲ ଲାଗି କାମ କଲେ ବି 10
ଆପଣ ଯଦି କନଭର୍ଟ କରିବେ ବର୍ତ୍ତମାନର ଡେଲି ୱେଜ୍ ର ଆପଣ ଯଦି 30 ଦିନ କାମ କରିବେ ଇଟ୍ ୱିଲ୍ ମୋର ଦ୍ୟାନ ଦ୍ୟାଟ ଆପଣ ଯଦି ଆପଣ 5 ଦିନ କାମ କରିବେନି 25 ଦିନ କାମ କରିବେ ତାହେଲେ ବି ଅଧିକ ତାଠୁ ହବ
at the same time
ପ୍ରୋବ୍ଲେମ ହେଲା କଣ କି you have started imagining things ଆପଣ ଏଗୁଡା କୋଉଠି ପ୍ଲେ ନେଇଥିଲେ ଆପଣ ସିମ୍ କଲେ ମୋର ଆଜ୍ଞା ବସ୍ ବିଜନେସ ବନ୍ଦ ହେଇଗଲା ମୋର ଦୋକାନ ବନ୍ଦ କରିଦେଲି ମୋର ଜିଏସଟି ନାହିଁ exactly like Sahid Khan.
He has filed the GST.
Exactly. GST is not GST file kale. Under impression that GST file kale je court raji hejo je na mor kichi ta GST jo dogni se dabani maintenance. Court the law develop heichi. Court is sandre achi. GST no dele maintenance dabani boli. ଆପଣ 50,000 ଜାଗାରେ 10,000 ଦେଲେ ସେଇଟା ଅଲଗା କି ଆପଣ କରିଥାନ୍ତେ ଆପଣଙ୍କ ଇନକମ୍ ଅନୁସାରେ ଲକ୍ଷ ଟଙ୍କା ହବ yes you should have given the case there not here revision there is no scope for interference
that's why I have challenged
in Samima Faruqi the
court has not considered
Supreme Court has said since Justice Mishra as the lordship then was the clear case of non-application of matter by the High Court that sort of a comment has been given.
This case should be considered, my lord.
Exactly, the same plea was taken.
He's not able
job. It is the chakri nahi. Sahid Khan resigned from job. This is not very difficult, madam. Also, if you think that you may be thinking that you can't podi asle kohunchoti, seta bhi ete difficult no. It is there. It is there for everyone to read. Anyway. Yes, item 40. So that's
Lord, both of these applications are arising out of the common order, my lord. Order passed under section 24 for interim maintenance. I am for the wife, and husband has also filed the application to set aside the entire order, not even saying that it has to be reduced. Lord, they have.
If jore chauchodi enhancement pai jore chauchodi deny korchodi, if you can agree. Discuss and agree for an amount.
The sad part is they have not complied even the order in a single month. There is a outstanding of 2,50,000.
That is very typical. That is very
typical
behavior.
They have to comply with the order since.
And sometimes actually we have encouraged that as courts also.
And many dates have already been the order has been passed, but not a single pie has been given. My only prayer is at least 50% as Lordship directing on all the cases.
On behalf of.
अरे on behalf of जे पैसा टा भी on behalf of तांकर आपण को निजे देबे ना को instruction नियम हला
After.
40 टा को week commencing 18 कर दियो
Lordship, my only prayer is Lordship direct only that part. my lord.
Mr. Praveen Das for the petitioner first matter opposite party your name sir आपण को नाडा
PK Panda. On behalf of
PK so PK Panda on behalf of SK Tripathi BK Panda on behalf of SK Tripathi for the opposite party WPC 1849 sir petitioner submits that despite the direction of it can stay hitch in account
No, my lord. No stay has
despite direction of the Guardianship Judge Family Court Bhadrak
Bhubaneswar, my lord.
sorry I would case call
My lord.
Bhubaneswar no amount has yet been paid Learned counsel for the opposite party shall obtain instruction to deposit the amount of arrear till date by the next date list for orders in the week commencing 18/5/2026 WPC 1694/5 of 2025 Mr. Ponda on behalf of SK Tripathi for the petitioner Mr. Praveen Das for the opposite party the petitioner husband challenges the order passed by the Learned Judge Family Court Bhubaneswar directing payment of monthly maintenance. This is 24 application.
24 application.
Directing pendant late maintenance on the section 24 of the Hindu Marriage Act. To sustain the challenge, the petitioner has to deposit the amount to secure the amount, which is in the nature of a money decree. In view of the judgment of the Honorable Supreme Court in Rajneesh versus Neha stuff, the Learned Counsel for the opposite party has adjournment to obtain instruction. The matters shall be listed for orders in the week commencing 18/5 along with the connected WPC 18497 of 2025.
The second sub item counter-affidavit.
Counter दरकार नहीं है ऐसा कौन read record administrative action है इतने तो this is the nature of 227 counter accept करेगा कथा नुहो जो latest judgment आसी region तले 227 में to what extent High Court can examine same principle but more कहेगा था जे nowadays things are so fast it is pops up in your live law and all these things so ना तो ना तो पास
pattern to mention item 30
30 डेट ହେଇଛି ବୋଧେ କରିଦିଅନ୍ତୁ ଆପଣଙ୍କ ଡେଟ୍ ଚାହୁଁଛନ୍ତି
ରିଜଣ୍ଡରଟା ଫାଇଲ ଅନ୍ ବିହାଫ୍ ଅଫ
ସେ ଯେବେ ଆସିବ ଦେବେ ଆପଣ ରିଜଣ୍ଡର ଫାଇଲ କରନ୍ତୁ ରେଜିଷ୍ଟର ଏଠି ଦିଅନ୍ତୁ ଡିଫିକଲ୍ଟି ଅଛି ଏଟା ପେପରଲେସ୍ କୋର୍ଟ ଆପଣ ଡେଟ୍ ମାନେ ଆଫ୍ଟର ଭ୍ୟାକେସନ
13
13/7 କହୁଛନ୍ତି